Testing 1, 2, 3. This is a test of the 7th Circuit YouTube live stream.
Very good.
Good morning, everyone. Our first argument of this morning, this calendar is in appeal number 221724, Fidelity and Deposit Company of Maryland versus TRG Venture 2. And we'll begin with Mr. Kropp.
Yes.
Good morning to you. You're welcome.
May it please the court, counsel. My name is Dave Korup and I represent F&D. I will be addressing the issues today concerning the bankruptcy court's interpretation and application of the Supreme Court opinion in Taggart v. Lorenzen. And if it please the court, my associate, Ken Thomas, will be addressing the jurisdiction issues at the end of my presentation. Despite this case's long and somewhat complicated procedural history, the issue before this court is straightforward. Did TRG prove, by clear and convincing evidence, that there was no objectively reasonable basis to conclude the plan release might release TRG? And I emphasize the word might because that's the exact word the Supreme Court used in articulating the standard that a bankruptcy court is to apply. The court said that the moving party must establish that there was no objectively reasonable basis to conclude the creditor's conduct might be unlawful. And that worst use of the word might teaches us that it wasn't sufficient for TRG simply to prove that a reasonable interpretation of the plan release would have released TRG. It wasn't sufficient for TRG to prove that the most reasonable interpretation of the plan release was to release TRG.
Release TRG or release the indemnity claim? What's the right question there?
Release F&D's indemnity claims against TRG.
Okay, well, they weren't held against TRG in the first instance, right?
In what sense, Your Honor?
The indemnity agreement was not with TRG, right? It was with, Kimball Hill, KHI?
Exactly, and those indemnity claims were completely different. Those indemnity claims were based on a bond that had a contractual obligation that required the debtors to indemnify F&D in the event Kimball Hill did not perform. Those bonds did not apply to anyone else's failure to perform whatever other obligations they may have. And what we've learned from the Illinois Appellate Court is that TRG's obligations under the annexation agreements are not the same as the debtors. And in fact, the Illinois Appellate Court held that both parties at some point became jointly liable to perform those obligations. And the reason we know this is because it wasn't necessary for F&D to obtain common law indemnity against TRG to prove that it had an indemnity agreement that was still enforceable with the debtors. In fact, that claim had been released. The only thing that F&D had to prove on its indemnity claim was that it performed the obligations under the annexation agreements, which it owed to the cities, which were not released, and that bestowed a benefit on TRG, who also had its own separate obligations under the annexation agreements to perform those obligations. And what the Illinois Appellate Court held was, in that situation, F&D is entitled to common law indemnity because it has bestowed a benefit on TRG. It did not have to prove in any way that at some point the debtors also owed indemnity under a contract for their separate obligations to perform under the annexation agreements. And importantly, TRG didn't have to establish that the debtors didn't perform the obligations under the annexation agreements. That was not part of its case. Once it purchased the properties, it obtained its own separate obligation to perform under the annexation agreements. And in fact, in the lower court, in the circuit court, one of the defenses that TRG asserted was that when the debtors were released under the annexation agreements themselves were released. And it lost that argument in the appellate court. The appellate court held in no uncertain circumstances that now that TRG was the owner, it now had obligations under the annexation agreements.
So your contention, and if I have it straight then, is that it's not so much that TRG stepped into the contractual indemnification obligation that was held by KHI, but rather by operation of common law and taking on the performance obligation under the annexation agreements. That brought with it a common law indemnity obligation.
Exactly. And F&D did not bring a claim against TRG for breaching the bonds that F&D had entered into with the debtors. That was not at all part of its claim and was not necessary for it to recover.
Why isn't the common law, if I understand the theory, why isn't the common law indemnity obligation extinguished upon plan confirmation, or maybe the better way to say that is extinguished upon TRG acquiring the properties free and clear?
Because, and this is important, TRG did not acquire these properties free and clear. That is made explicitly clear in the lower court record. TRG never contended in the lower court that it was released from the annexation agreements. And in fact, if you'll recall, the bankruptcy court in its 2017 opinion says the parties don't dispute that the annexation agreements continue to be binding in this case. And what the Illinois appellate court held was that simply by buying the property, a new obligation arose on behalf of this new buyer. That's how annexation agreements work. They are a creature of contract, but they're also a creature of statute. And that's why TRG did not purchase this property free of the annexation agreement. The other thing we know, and it's undisputed, is that the municipalities never released their claims against TRG.
But wasn't that a losing argument in several of the state court cases?
No, the release was never addressed in the state court. TRG, for 6 years, never contended it was released in the state courts. That issue was never raised. The only thing that TRG ever brought up in the state court was that somehow the bankruptcy, because it released the debtors, that somehow extinguished the annexation agreements. And we know from the Illinois appellate court decisions, they rejected that, and they said absolutely not. The annexation agreements continue to bind. So that's a key point. TRG never understood it was released at the time it purchased these properties, and for 6 years, never asserted that defense. And it was an obvious defense in this case. Why would you possibly litigate in 5 separate circuit courts on the merits of the case when you have a release that you contend is not only releases F&D's claims, but there's no objectively reasonable basis to read them in any other way? And there's record evidence that we've cited to where TRG argues to, because remember, back in 2017, when we weren't applying Taggart, one of the defenses that F&D raised was latches and waiver. F&D said, well, wait a minute, TRG, you waited 6 years to finally raise this. It's too late. So in the bankruptcy court, TRG argued it didn't understand that it had been released. That was its theory. And so it said to the court, why would we ever sleep on our rights, Your Honor, when we could just come before this court and in one fell swoop moot these arguments?
Why is it that, I mean, this may sound like a strange question, but you read the bankruptcy court order, you read the district court opinion, and they seem to be talking about a different case than you're describing. They seem to be saying this is a an intentional and blatant violation of the plan confirmation order. Why is it that they're so far afield from what you're now describing?
I have 2 responses to that.
I mean, it's not even, those opinions say it's not even close. This is deliberate.
Yes. And let me explain why this, I believe, is one of those unique cases, and I know they're unusual, where the common law record simply does not support these factual findings. Remember, back in 2017 and 2019, Taggart was not the standard. So There was no requirement to prove that TRG's or F&D's subjective knowledge one way or the other. The only thing the bankruptcy court cites are snippets from the litigation committee at F&D that referred to litigation as novel or unique or testing a theory. We would submit that's far from clear and convincing evidence that F&D knew with certainty that TRG had been released. And keep in mind how any lawyer would advise a client in this situation. There are many times when you tell a client, you have a 60% chance of losing, you have a 40% chance of winning. And we're going to make the 40% argument because there's an objectively reasonable basis to make that argument. It might be wrong. It might not be the most reasonable argument. But Taggart is a rigorous standard. Taggart says there has to be no objectively reasonable basis to make this argument. So we would submit to you, Your Honor, that and let's look at what else the bankruptcy court cited in 2020. And remember, this was a sea change in how bankruptcy courts were allowed to hold parties in contempt. Before this, as Taggart points out, it was akin to strict liability. You just had to prove the creditor knew of the bankruptcy order and intended to do what it did. The other thing the bankruptcy court refers to as showing F&D knew is, and I'm going to quote here, F&D knew based on the prior case law involving it, the results of its actions taken before this court, the state court, and the district court, that it was acting in contravention of the plan injunction. Under Taggart, F&D would therefore be subject to civil contempt. Well, we know that the bankruptcy court decisions in 2017 and 2019 were pre-Taggart decisions, so they didn't apply that standard. We also know they came years after F&D sued TRG. They couldn't have possibly provided F&D with knowledge at the time it sued TRG. We also know that the state court decisions never addressed the release at all, let alone Taggart. And finally, we know the district court couldn't possibly have provided that knowledge because the district court didn't apply Taggart. It vacated and remanded the case so that the bankruptcy court could do that. The other thing I would suggest, Your Honor, is if you make what the bankruptcy court here did was, rather than applying an objective standard, reading the confirmation order, applying Illinois rules of contract construction, and identifying ambiguities and construing them against TRG's interpretation. That's what the law would normally require when you're objectively trying to figure out, is there an objectively reasonable argument? Instead, it first decided, did F&D have an understanding that TRG was released? It then proceeded to shift the burden completely to F&D to prove that the plan release was unambiguous in not releasing TRG. That effectively made F&D's subjective understanding dispositive. And that's exactly how TRG, in its brief, argues to this court that is the standard according to TRG. They say even if it is subject to credible debate about what the plan release means, as long as F&D had this understanding, it should be held in contempt. And we would submit, Your Honor, there's absolutely no support in Taggart for that shifting of burden or for making contemner's supposed subjective understanding completely dispositive of the issue.
Why don't we hear from, you want to save a little rebuttal time?
Yes.
Why don't we hear from Mr. Thomas on the, you said jurisdictional issue,
Yes.
correct?
Thank you.
Okay, yep, very well.
May it please the court. Ken Thomas on behalf of F&D. The bankruptcy court exceeded its subject matter jurisdiction when it interpreted and enforced the plan release and injunction to apply to claims that it could not have enjoined in 2009. F&D's claims against TRG had not yet arisen at the time that the plan injunction was entered, as TRG had not taken title to the property, in this case, until 2010. When those common law claims arose, they didn't arise under the bankruptcy code. They arose under the Illinois common law. And they didn't arise in a bankruptcy case because they could be litigated in the state courts and they weren't unique to bankruptcy. As to related to jurisdiction, these claims does not directly and substantially affect the amount of property available for distribution to creditors or the allocation between creditors, a narrow standard as the Seventh Circuit interprets it. And that's the case for two reasons. First, TRG is not a creditor of the bankruptcy estate. They never filed a proof of claim. So this could not be a dispute about the allocation of property among creditors. As to the property available for distribution, TRG doesn't allege that there has been an effect on the property available for distribution.
Why is there a lack of jurisdiction, though, under 1334 related to when the argument is that that TRG is violating an indemnity obligation, right, that was extinguished upon plan confirmation? Your argument, Mr. Thomas, seems to me more to be one on the merits of the underlying question, but why does the district court lack jurisdiction to resolve that contention?
Well, as with any injunction, Judge Scudder, every court that enters an injunction over certain claims has to have jurisdiction over those claims.
No, I get it, absolutely. But if your argument is right on jurisdiction, I don't understand how the 2019 Travelers insurance case is correct. Or for that matter, why is there no lack of federal jurisdiction in Taggart itself?
Well, Travelers tells us, well, let me address the Taggart question first. Because Taggart was enforcing a discharge injunction provided by statute, those rights arise under the bankruptcy code. So we're not talking about a discharge here. We're talking about a consensual plan release. And under Travelers, and those are different because one is provided by statute and has to be provided in a Chapter 7 case, which is what Taggart was, and the other is provided by consent of the parties. In fact, 524 of the Bankruptcy Code says that liquidating Chapter 11 bankruptcy cases, which is what this is, are not entitled to statutory discharge. They're not entitled to a discharge under the Bankruptcy Code, and so they only get what the parties write in a specific release, and that's not a right provided under the Bankruptcy Code. As to your second question about Travelers tells us that parties cannot challenge the subject matter jurisdiction of a court to enjoin claims in a subsequent proceeding if the parties had a full and fair opportunity to litigate subject matter jurisdiction in the first instance. And here, there was no full and fair opportunity. Neither of the parties understood this plan release to apply to F&D's claims, as is clear in the record. And in Travelers, they relied on an unambiguous injunction. That's why they read the injunction first and held it to be unambiguous. And as a result of that, they were collaterally barred from challenging it. But here, we've always maintained that the plan release is ambiguous. The parties did not have a full and fair opportunity to litigate that question, and this was the first time we had an opportunity to do it. And I'll add that one of the exceptions to collateral bar, if Your Honor is inclined to find that, is that it would impinge substantially on the jurisdiction of another tribunal. And the state courts had been litigating this for 6 years on a question that, if there is related to jurisdiction, is concurrent jurisdiction. And so to come to the bankruptcy court and say, hey, we're going to find another route to winning our cases in the state court, we would think that that would be an exception to the collateral bar challenge.
Thank you.
Thank you, Your Honors.
May it please the Court. Bill Thorsness for Appellee TRG. Before I begin my prepared remarks, I just wanted to respond to a few points opposing counsel made. First of all, that we somehow conceded in the lower court that the annexation agreements were either relevant or binding. That's simply not true. Or that the municipalities had continuing, or that we have continuing obligations to the municipalities. None of that was conceded. Judge Barnes assumed that to be true because in the first few pages of our motion and at every hearing, we said that doesn't matter. Judge Barnes agreed that neither the annexation agreements nor any obligations that TRG might allegedly owe to municipalities does not matter here. And we'll get to why.
It does not matter for purposes of an indemnification obligation?
Does not matter for purposes of whether the injunction precluded Fidelity from suing us.
On what? The indemnification obligation?
Absolutely. And absolutely, you're right, Judge. Now, in addition, counsel stated that the record shows that TRG never understood that we were released, and that's why we never pursued in the bankruptcy court earlier than we did. That's also not reflected in the record. Rather, what the bankruptcy court found, what the record establishes, is that TRG did not know it had a superior remedy in bankruptcy court until 2016. And that's based on the credibility determinations that the bankruptcy court heard, and that's based on the fact that until that time, TRG had no need to evaluate other remedies. That is supported by this court's decision in Chicago, Milwaukee in 1993. So what happened was, in 2010, no one had seen this type of an aggressive suit by a surety in the country's history. Fidelity admitted it had never tried this before, ever. Fidelity admitted no other surety had ever tried this before, suing successors, notwithstanding a bankruptcy order, after a sale. Fidelity gambled, knowing in a down market, attempting to preserve its bottom line. And TRG, when it was first sued, spoke with all of its lawyers, spoke with its SunCal, the largest private real estate developer at the time in the country, who bought 15,000 lots out of bankruptcy at the time, had hundreds of years of experience with these exact issues. No one had ever seen these claims before. So they huddled, they talked about it. What is the quickest way we can get out of these cases, these state court cases, so that we can go on and sell the properties? And so they came up with a consensus, which was, let's file motions to dismiss on these bases in all 5 cases, and they won every time, quickly. None of these cases led to discovery. The dismissals were with prejudice, and it was only until Fidelity pursued an appeal in the Elgin case, and the Elgin court reversed, which is effectively a first of its kind decision. On motions to dismiss in late 2015, did TRG realize we got a problem here? They're going to do this in every case. This is not a short litigation with Fidelity. They're going to do this in every case. We're going to have to deal with discovery. And so they reconsidered their options, which is what any rational actor would do. It then realized it could come into bankruptcy court and seek enforcement of the confirmation order. That's what the record reflects. We agree on the Taggart issues, Judge. We agree with Fidelity that this is a single issue case. After 6 years, 100 pages of judicial decisions, 4-day trial, years of discovery, did Judge Barnes abuse his discretion in finding that there was not a fair ground of doubt that these acts were enjoined? Now, whether it's before Taggart or after Taggart, to answer that question, one would naturally look to the 4 corners of the confirmation order, informed by context, and ask whether there is any supporting case law to sustain that proposition.
Can you put a bookmark on that thought? Because Mr. Thomas has argued there's not even Judge Barnes doesn't even have jurisdiction.
Absolutely. Well, we can turn to that first, Judge Scudder. Sure. There are multiple bases for jurisdiction. The first is that there is clear core jurisdiction. Whenever you have a buyer from a liquidating trustee, as here in a Chapter 11 case, coming back in, enforcing a confirmation order before any distributions are made in the case to unsecured creditors against the pre-petition disgruntled creditor, that is core jurisdiction arising in and arising under. Their only argument in response to that is that there was not a technical Section 524 discharge injunction. And while that might be true, that's a distinction without a jurisdictional difference, because there is multiple statutes under the Bankruptcy Code and Fidelity's own participation in the case which demonstrate that this invokes a substantive bankruptcy right. All over the confirmation order and the debtor's briefs in support of the confirmation, they rely on 1123b3 and b6, as this court itself relied upon in the Ingersoll case in 2009 to support the enforcement and implementation of an injunction in a liquidating Chapter 11 case. This is not a reorganized Chapter 11 case. So 1123 provides that direct injunction, as well as Section 105, 1129, 1141, and 1142, which in every liquidating case, these are how injunctions are implemented and enforced. So there's core jurisdiction here. You can't resolve this case without evaluating the Bankruptcy Code. Second, to your point, Judge, I The Travelers case and multiple Supreme Court cases, including multiple Seventh Circuit cases, squarely support the exercise of inherent jurisdiction here. A court, any bankruptcy court, has authority to enforce its own injunctions. It's not simply interpreting an order. It's enforcing an injunction that it itself entered. Travelers, you can't rebut the Travelers case, the statement it makes regarding jurisdiction. It's clear. They said it's easy. There's not a factual distinction. It's a legal proposition. Relatedly, there is ancillary jurisdiction of a bankruptcy court. This court held in 2013 in the Sweetports case that a bankruptcy court has ancillary jurisdiction. We didn't hear about that today, but Fidelity in its brief criticizes the language in that case, seizes upon the characterization of ancillary as cleanup jurisdiction, which is what the phrase Judge Posner used, and suggests that this can't be cleanup because look what happened. This took 6 years. How can this be cleanup jurisdiction? Well, that proposition cannot stand because if any time someone gets sued or defendant in a contempt case, you can sandbag a jurisdictional defense by having an aggressive litigation strategy. So that promotes bad incentives. It has to be the substance of the dispute that is the proper jurisdictional test. And finally, related to jurisdiction. In the Bush case, which we also didn't hear about today, in 2019, this court held that the test for related to jurisdiction is made at the time the dispute is filed. And at that time, what is the potential impact on creditors? So what do we know? In 2016, July, when TRG first filed this motion, we know two things. We know three things. First is that the Kimball Hill Trust was holding $55 million of cash, to distribute to unsecured creditors in Fidelity's class, the C2 class. It had not made a single distribution yet. It was hoping to do so within that year. At the same time, Fidelity had $4 million of liquidated additional claims that had not yet been allowed, but for which it absolutely could and should have sought reconsideration. And third, most dispositively, at the same time we filed our motion, Arch Insurance Company, its sister surety, filed a reconsideration motion, and the trust objected. We raised this in our opening brief. Judge Barnes overruled the trust's objection, granted reconsideration because Arch also had liquidated claims to the municipalities. It was a pro forma exercise for Fidelity to seek reconsideration. The only argument they raised in response to that is a statute of limitations defense, that it was too late, could have been too late. That's wrong for at least three reasons. First, they only raised that on reply. We didn't have an opportunity to respond to it, so we submitted to waived. But more substantively, Fidelity's allowed claim in 2013 was not a final order to which Rule 60B applies. That's because it was expressly without prejudice to Fidelity's right to seek reconsideration under 502J. Judge Barnes invited reconsideration.
In the event there was more paid out on the performance bonds?
Absolutely. That's how it's done with sureties. It's a typical contingent claim of a surety. Well, we haven't come out of pocket yet, but let's wait until we do, and let's go assert our claims. And that's what Judge Barnes said multiple times, and that's how Arch was done. The last reason is that the statute of limitations does not apply to this type of a reconsideration. There's only three reasons under Rule 60B: mistake, newly discovered evidence, and fraud. This is a B6 issue, as all of the cases that address surety cite, none of them of which are provided by Fidelity. All of them are provided by Arch in their papers. We didn't have a chance to submit those cases because we heard about it on reply for the first time. The last issue on jurisdiction I'll just raise is that we have no answer for why Fidelity never sought reconsideration. The only thing that now makes sense, they had $7 million of claims. This case paid out 55% distributions to unsecured creditors. The Kimball Hill Trust did an outstanding job in a down market. That's $4 million Fidelity would have gotten. Why would they walk away from $4 million? We've never heard an answer to that. The only thing we can come up with is that they were trying to intentionally gain a jurisdiction defense. And that, as a matter of law and fact, that cannot be a reason. It cannot be relevant to the jurisdictional analysis. Unless Your Honor has more questions on jurisdictional. So back to the Taggart issues. So the confirmation order we submit is unambiguous. It passes property free and clear of all claims, and claims as giving the claims is given the broadest definition possible, and all interests, which include successor liability claims. And the confirmation order gets Fidelity coming and going in that these claims are squarely released. This today is another collateral attack on the release that they voted for 14 years ago. But even if there's a dispute about whether it's released, these claims were settled. The injunction independently enjoins Fidelity from pursuing settled claims.
It does seem there may be an issue of the shifting of the burden here, though, which is a point that F&D is raising. Do you know of any post-Taggart cases that shift the burden to a defendant to show that there's no fair ground, as opposed to the typical posture, which is that the movement always has the burden to show contempt?
Yes, there is. There are cases that do that, Your Honor, but I believe it's a false premise. What Fidelity is really saying is we, as a movement, have to divine in advance all potential arguments Fidelity might make as to why this is objectively reasonable. What pre-Taggart and post-Taggart the burden is and should be, is there an order? Does the order prescribe certain conduct? Was that conduct taken? We've done all that here and more. And then naturally, the contemnor should come to the court and explain why what they did was justified. What is their belief as to why it was justified? And the touchstone in pre-Taggart cases, and certainly in all of the 325 cases as of yesterday that rely on Taggart, is there supporting case law to support your position? There is not one case anywhere that allows a surety's claim to survive a confirmation order. Fidelity admitted that in its first hearing in October of 2016, and nothing has changed. So while some post-Taggart cases do discuss burden in that context, none of them shift the burden and allow the contemnor to blame the victim for why it violated the confirmation order. But all the Taggart cases, most of them at least, what they come down to is there supporting case law? There's none here. This is not a unknown tort victim case where a pre-petition manufactured defect, tort victim didn't know that it had a bankruptcy remedy, didn't know they had a claim in the bankruptcy, and so those claims could survive for due process concerns. That's not this case. This is also not a, for example, private student loan case where on the one-line discharge order there's current debate in the courts on whether a student loan debt survives. That's not what we have here. There are multiple cases going both ways on all of those cases. There's not a single case supporting what Fidelity is asking you to overturn today. The claims are, let me back up, excuse me. Fidelity only first challenged the release that TRG is not a successor on its reconsideration motion in 2017. We submit that's waived, but even if it's not, Fidelity only contends that TRG is not a successor. That's their exclusive argument. They don't contend that we're not an assign. But if we're not a successor, we are, but if we're not, we're absolutely an assign. And how do we know that? We know it because paragraph 1A of the purchase agreement says Kimball Hill is assigning all of its interests to us. We also know that because Fidelity admitted that the plan does not releases all claims against assigns. That's in their first appellate reply brief on page 37. Now what happened here makes perfect sense. The purpose of a liquidating plan is to channel all claims of creditors and maximize asset sales to maximize distributions to those creditors. That's what happens in every case. The successor and assigns provision is not some miscellaneous boilerplate that no one thought about. The debtor's brief in support of confirmation says this release is so essential because otherwise there will be a threat that pre-petition creditors can attack the liquidation trust and continue their claims. That's the whole purpose for these things. Now, how do we know that they are pre-petition contracts and did not somehow survive, in addition to the absence of case law? A number of reasons. The bonds, however you want to characterize Fidelity's claims, they arise under pre-petition agreements, whether they're bonds, whether they're annexation agreements, or whether they are the indemnity. All were executed pre-petition, and all went in hand with each other. Fidelity's would not have a claim against anyone but for the indemnity. They would not have a debt against anyone but for the bonds. They are a garden variety surety who bargained for this exact risk when it got premiums 5 years earlier and promised to bond the municipalities in the case of this exact situation. And that's why the municipalities in the annexation agreements require bonds. And that's why in favor of the bonds, in exchange for the bonds, Fidelity needs an indemnity. Now, this court's St. Catherine's decision is squarely on point, where it rejected the accrual test and held under the conduct test. Claims we review when a claim arises at its earliest possible point. And here it's simple. These are contracts. When were they signed? All pre-petition. If you line up Fidelity's allowed claim, claim number 1636, and in that claim allowance order, it identifies Fidelity's claim 1636. The docket number 3546 in that case is a 30-page document. If you line that up against the state court complaint that Fidelity filed against us, there's nothing different in there. They're identical claims. And they don't need to be identical, by the way, to be enjoined. They have to be related in any way. Fidelity's arguments wrongly focus on the alleged nature of our obligations, not on the nature of Fidelity's claims. Under any law, surety law, release law, that is judged at the time Fidelity signs up to those bonds and signs those contracts.
Yeah, I have a hard time seeing why it is that if TRG has continuing development obligations under the annexation agreements, that could somehow give rise to an indemnity obligation under performance bonds. That's the argument they're making it common law, right? Because the reason that you're emphasizing that this is pre-petition contractual, I think that the reason you're spending time on this is because your point is that was extinguished at plan confirmation. We took it free and clear of that obligation.
Any of Fidelity's claims and obligations.
Right. That's why you're focused on that, okay? But your adversary was arguing, we're not arguing about contractual indemnity, we're arguing about common law indemnity, post-petition common law indemnity. What's your response to that?
Absolutely. The definition of a claim is as broad as possible, but it means right to payment, whenever existing, arising in the future, based on any conceivable legal theory. The right to payment that Fidelity had existed before the case, whether the property was sold and whether the property has binding obligations under TRG. Now, the annexation agreements are certainly interesting and important, but they're not relevant for multiple reasons. Because if Fidelity believed it had a right to preserve, believed it had a right under annexation agreements that it wanted to preserve, it should have raised its hand and objected to the plan when it voted for it.
Do you think that's what they're arguing? I don't think they're arguing that the indemnity obligation is somehow embedded within part of the annexation agreement. I don't think that's what they're saying. I think he's saying it's coming from common law based upon post-petition activity.
But that post-petition activity was known, inevitable, before the bankruptcy case, and it's embraced with Fidelity's claim, which is exactly what the bankruptcy court held, and St. Catherine's as well. That the claim, the potential that a subsequent developer would have obligations under the annexation agreements was inevitable way back in 2007. Fidelity knew it would have obligations on these bonds. It knew Kimball Hill was liquidating or was going to go away. It filed a UCC before the bankruptcy case. It asked for more collateral against Kimball Hill before the bankruptcy case. And in 2008, in the height of the Great Recession, they knew Kimball Hill was going away. But whatever rights a municipality has to enforce an annexation agreement obligation, rights that have never been established in fact under any case, that is an in rem right that a municipality has. It is not transformed. Whatever Fidelity can get from a municipality is an in personam right. Fidelity admitted all it has, if anything, from the municipality is a, quote, monetized legal remedy. All cases that Fidelity and Amicus cite related to annexation agreements hold that the annexation agreement is only enforceable and relevant to the party to it, the municipalities or landowners.
Which is why they tried to get the municipality to sue TRG in state court, and a lot of that was unsuccessful.
Exactly. It was all unsuccessful. 2 municipalities ultimately did sue in an election season, and those cases were quickly dismissed, but the record shows those municipalities would not have sued, would not have done anything but for Fidelity's contempt. Yeah. They're all Fidelity. If I can make one more final point, Judge.
Go right ahead.
Yep. The state court dismissals, and then I'll end, we submit are entirely irrelevant for 2 reasons. First is that they were decided on motions to dismiss, where the courts all accepted the allegations as true. Those weren't municipality cases against TRG. They were up on Fidelity's counterclaims or third-party claims against TRG. More importantly, those dismissal decisions were generated from contempt. They were the product of contempt. So Fidelity is arguing that somehow the fruit of the contempt can somehow sanitize the tree. And that's just now not how it works.
Okay,
Thank
very
you
well.
for your time.
Yep. Okay. We'll go back to Fidelity for about 3 minutes, a little more than 3 minutes for rebuttal.
Your Honor, there are several points I'd like to briefly address. Number one, it's important for us to focus on the actual language of the plan release itself. The plan release only released parties that were identified in the plan release. So regardless of whether there might be another defense that a particular claim was released, no claim was released against a party unless it was identified in the plan release.
Is that entirely the case, Mr. Corrupt? Because it's standard contractual language that identifies debtors and then assigns and then successors, and it's defined throughout the contract.
Well, and let me address that. The plan release does not use the word successors. It's not in there. There's a miscellaneous provision that refers to successors and assigns. There are other parts of the confirmation agreement where, for example, holders of claims. That term, the party specifically said holders of claims includes successors. They didn't do that in the plan release. And under Illinois law, a court isn't allowed to accord meaning to that omission and that difference. And again, all we're trying to find here is, was there any objectively reasonable basis to argue that TRG might not be released? It doesn't have to be the most reasonable. It doesn't have to be the interpretation that the court finds is the best interpretation. The question is, was it objectively unreasonable? And we would submit, if the language supports the argument, which it does here because the word successors is not in there, and it is in other provisions, and there's Illinois case law that says a court is entitled to accord meaning to that, that by definition is an objectively reasonable argument. It might not be a winner, but it's an objectively reasonable argument. I couldn't be sanctioned for making that argument. There'd be no Rule 11 issue, and that's the Taggart standard. Taggart is saying, can F&D even raise the question of whether TRG was released? And Taggart teaches us that yes, if you have at least an objectively reasonable basis to do that, you're allowed to raise the question. The other thing I would like to address is when these claims were originally filed, this was a reorganization. This was not a liquidation. And we know that at that time, they had represented to the court that they had a legitimate basis to believe they might continue on as an ongoing business. And the last thing I would like to address briefly is the bankruptcy code gives the parties, the trustee and the creditors, the ability to decide what is the best way to maximize creditor recoveries. It doesn't require that buyers release, or the creditors release buyers from the bankruptcy estate. But if TRG's position is accepted, if the bankruptcy court's position is accepted, then that's a bright line rule. They always have to be released, and there is simply no authority for that. And in fact, in this case, it made sense, this is my last comment, because we know that the municipality's claims were going to continue no matter what. They weren't released, so there was no reason that they had to release F&D's claims either. For that reason, Your Honor, we ask that the district court's 2 opinions be reversed, and in the alternative, that the contempt order be vacated.
Okay, very well. Thanks to both counsel. The court will take the case under advisement. We'll move to our second argument of the morning, number 22-2083, in re Degen Law. Counsel for the U.S. trustee, Mr. Aguiar, I know you're going to appear remotely. We can see you just fine. Can you hear us?
I can hear you perfectly well. Thank you.
Okay. Mr. Mendito,
Yes, Your Honor.
good morning.
Good morning, Your Honors. David Mendito on behalf of the petitioners, Jim Ford and his law firm, Degen Law, but I'll be referring to the firm as Upright or Upright Law like we did in the briefs. The court has already given the petitioners the first shot at briefing. Well, you didn't give it to us. We filed our petition, but you gave us a reply, and I know the court has read the briefs, so I'm not coming with as much prepared comments as the attorneys that argued the last case. There was a lot of very record-specific things they wanted to bring up. Here, I think it's a little cleaner. But I do want to offer some opening comments. I'll keep it short, and then apprise the court of some recent events in that Fifth Circuit decision in Jarkissi that just came down that I think is going to be relevant for the court's analysis here. Civil juries have long served a critical check on government power. The Constitution would not have been ratified if the founders had not assured private citizens a right to a jury trial in government actions in which they seek a civil penalty. This is one of the main points that Jarkissi decision makes. And in support of it, they cite Federalist number 83 in the Supreme Court's decision in Parsons versus Bedford, which is at 28 U.S. 443 or 433. Now, the Supreme Court in Tull has firmly established that when the government seeks a civil penalty, it gives rise to a jury trial right. Okay? And this court affirmed it in the Lipson case, and the Ninth Circuit affirmed it in the Jensen case that we cite, where the government sought a jury trial right. And the court said, yes, you're entitled to that. Because
Mr. Mendito, let me ask you this, just in the interest of time. Has any court in the United States, state or federal, to your knowledge, held that you have a Seventh Amendment jury trial right on a 526C5 civil penalties claim?
No court has held that position. As your court is aware, the lower courts obviously ruled against us on that, and then there is a Vasquez decision out of the Southern District of Texas.
So if we don't have, how then, given that reality, just measurement of the case law, where the case law is at right now, how is it that you can claim entitlement, at least clear entitlement, to mandamus relief? I mean, the reason I'm asking you the question that way is because I'm thinking about the Cheney factors. And I'm thinking in particular about the second of the Cheney factors, the clear and indisputable or clear and unmistakable right. Okay? And what is it that you would point to that makes it clear and unmistakable?
The clear and unmistakable right comes from the fact that the government has sought a civil penalty, which is legal in nature, and has traditionally was always tried by the 18th century courts of England. The only exception to that would be if the private rights exception to the jury trial right. Well, Grand Financiera is clear on what that entails. It has to be, did Congress assign this claim to a non-Article 3 tribunal, and does that non-Article 3 tribunal not use jury trials? Okay? That's not what happened here. But that was the holding of Vasquez. That was the holding of the lower court. Okay. But here Congress has not assigned 526 claims to a non-Article 3 tribunal that doesn't use juries. We know bankruptcy courts use juries. And they have the authority to use juries with the consent of the parties to litigation. And also, Congress did not assign these cases to the bankruptcy court. These cases are assigned to the district court.
You think that, isn't that a bit of a legal fiction as far as the way bankruptcy operates today? In other words, why isn't the more reasonable, practically accurate conclusion here that Congress effectively has assigned core matters to a bankruptcy court? Effectively. You know of any district court that's retaining jurisdiction in bankruptcy?
No, there aren't any, Your Honor, of which I'm aware.
Right.
Okay. But you look at the statute that Congress passed. The fact that the district courts subsequently said, yes, we are going to refer these cases to the bankruptcy court doesn't change the fact that what did Congress do when it enacted this statute? It gave original jurisdiction to the district courts. And even if it did assign these cases to the bankruptcy court, This is not a court that does not use juries as fact finders, okay, because bankruptcy courts do. The third prong of grand financier is just not met. And the lower court got it wrong, and the Vasquez court got it wrong.
Well, let me ask you about a different Cheney factor. Even if we agreed with you that there was a right to a jury trial here for 526 claims, why isn't this an issue that could be vindicated on appeal? Therefore, compromising your ability to satisfy the first Cheney factor,
Right.
because what you're really in here asking us for is this petition for writ of mandamus.
Right. I was going to reserve 10 minutes, Your Honor, but of course I'm going to answer your question, but I was reserving 10 minutes for rebuttal.
Yeah, no, well, hold on. Can you... All right. Yeah, why don't you go ahead and answer the question, and we'll worry about the rebuttal time when it comes up.
This case can't be resolved, or the damages and the harm that would fall upon the petitioners can't be addressed through an end-of-case appeal, because this case is one of 8 adversaries currently going on. Okay? Every one of those cases looks to the other cases to say these people, these petitioners, engaged in a pattern or practice of misconduct. This is not a unique case like the court found in First National Bank of Waukesha, where Judge Easterbrook said this is just one tractable
Aren't
case.
things like
Go ahead.
Aren't things like stays available to you?
We had the same question.
While you take this on appeal, why wouldn't a reasonable bankruptcy court judge say, you know what, I will stay these other 7 to see what happens with your appeal?
Well, it's not just the delay or the effect that these cases might have on one another. That obviously is not the procedural posture of the cases, but I think it's important to recognize here that when a jury trial right exists, especially in this jurisdiction where the local rule says once the jury trial demand is made and all parties don't consent to having the bankruptcy court try that, the case immediately goes to the district court. So there is an immediate right to have the case in an Article III court, and that is no small, that's not unimportant, okay? This is not a case where only the trial would go to the district court. Under the local rule 9015, the case immediately goes to the district court, which means the district court rules on any pretrial motions, okay? Discovery is going to be guided by any rulings. This case needs to be out of the bankruptcy court, which ordered the investigations that led to this adversary and the others, because the bankruptcy court would be ruling on discovery motions, which would guide the scope of interrogatories that are under oath, that would guide the scope of depositions that are under oath.
Are you saying no bankruptcy court would stay while the case is adjudicated in the district court, while the 8th case, for example, is adjudicated in district court?
What I'm saying is even if the bankruptcy judge were inclined to do that, the reality is let's say this is the one that proceeds, okay? If a jury trial right exists, it's not just the jury trial. In this particular jurisdiction, the case gets immediately removed to the district court, and that's significant because it's the difference between whether this Article I judge handles all the pretrial proceedings.
But that's only significant if the judge makes a mistake. I mean, you want a different judge. That's really what you're arguing. You don't like this bankruptcy judge, and you want the case removed now to the district court so you can get a new judge. This is not unusual in contempt proceedings. This happens all the time where a district court judge will refer one party or another to the U.S. Attorney's Office or for contempt proceedings and then preside over the contempt proceeding. We've held that's perfectly fine. And here, what I don't understand, I want to ask what Judge Jackson-Acumi is answering, because I'm not sure you've answered this question. If one case goes to a bench trial, which strikes me as more of a hearing, which can be conducted in a day or two, you can do it by affidavit. If it goes to a bench trial, the bankruptcy judge makes a decision and then stays everything else. It's just civil penalties. I don't understand why the bankruptcy judge wouldn't do that. It comes up on appeal and you get a decision on whether you have a right to a jury. If you don't, you try the other cases in front of the bankruptcy judge in a similar manner, and if you do, you retry this case to a jury and you try the other ones to a jury. Are you saying that the bankruptcy court won't stay the other proceedings to allow that to happen?
Your Honor, I don't know what the bankruptcy court would do. What I am saying is that even if the court were willing to do that, that doesn't carry the day. It's not
Because you're concerned with the rulings, that the pretrial rulings that the bankruptcy judge may make. But, right, that's your argument.
Certainly, we would not want unfavorable rulings by the bankruptcy court, but our concern is not this judge is going to make bad decisions. The concern is that we're entitled to have an Article III judge, the district court, make these decisions in this case.
Well, that's
That's
not
just begging the-
totally right.
Well, go ahead.
That's not totally right, because the district court judge has the authority to refer pretrial matters to the magistrate judge. So you don't necessarily have an Article III, the ability of an Article III judge to make all pretrial decisions, certainly dispositive decisions, but not routine discovery decisions.
Well, certainly there, but we're entitled to have it out of the bankruptcy court.
I think that just begs the question that Judge Jackson, it's not responsive to the question. And here, let me put it another way. Suppose that, contrary to your wishes, you go forward and your client loses the proceeding in the bankruptcy court. Civil penalties are imposed, and you appeal, and you argue that that proceeding violated my client's Seventh Amendment right. Suppose you win on appeal. What are you worried about? How can, if you win on appeal, how can whatever happened in the bankruptcy court, which would have happened in violation of the Seventh Amendment, have any preclusive effect?
On the evidence that's in the record based on what happened in the bankruptcy court, you know, this court's decision...
What is that? I don't know what that means. What does that mean? On the evidence?
On whatever evidence came out through the trial. There's going to be evidence that's in the record.
Of course, but your argument is grounded in doctrines of preclusion. What you're worried about is preclusive effect on other civil penalty proceedings, right? I mean, that's what you're worried about.
But there is also preclusive effect on what happens prior to the trial. Rulings on motions, evidence that's brought in, and these cases, even though the other cases are stayed, what happens in this case is going to be used and be relevant when those cases get unstayed.
Even if the entire thing is vacated because the Seventh Amendment was violated?
What's the support for that?
The support for that is the venue that you're entitled to be in from the onset of a case is, and being deprived of that is an irreparable harm that can support granting mandamus. And we cite this court's decision in Balsamo. And that was where a party wanted to move to transfer venue. And that motion was denied. Okay? And this court said, okay, it was entitled to be in a different venue, and the deprivation of that was the type of harm in itself, just being in the wrong forum, even if later the case might be vacated.
Okay.
That was a criminal
deprivation
case.
but it still dealt with the venue that the movement was entitled to, or the petitioner was entitled to.
Let me ask you, it's a flavor of the same question, okay? If this panel assumes, as we must, that this court's decisions in First National Bank and Caldwell Baker are good law,
Right.
and that they bind the panel, can we grant your mandamus petition?
Yes, you can, Your Honor.
How?
First National Bank of Waukesha ended up being a single count claim. It was a straightforward case. It was not seeking the type of civil penalty that we have here. And the court found that there was not going to be any preclusive effect on any other cases, based on rulings, holdings, otherwise. That's not what we have here. Even if we stay the other cases, there are going to be rulings, there will be findings.
That have
Depositions
preclusive
are-
effect?
Certainly someone's testimony can be used against them for impeachment purposes. Admissions could be used as evidence. Vacating the trial doesn't vacate everything that has happened in the lower court, doesn't vacate the preclusive effect of arguments that are made in briefs that might be used later for, well, you admitted this, you waived this argument.
Wouldn't that all necessarily be true within those kinds of risks? Wouldn't that all necessarily be true within the confines of the litigation of First National Bank and Caldwell Baker?
No, because those were not, because you didn't have the multiple cases going on.
You're not talking about multiple cases. You're talking about what happens in discovery could functionally and effectively have a preclusive effect. You know, somebody testifies, you can get the transcript and impeach her, etc. That's the kind of stuff. You're not talking about claim preclusion as a legal doctrine. You're talking about more functional.
And why wouldn't that be the case in district court too? Say you're in district court where you want to be, having your trial, that same discovery would occur, those same depositions, that same testimony.
Yes, it would, Your Honor. But if you have a right to a jury trial that gets you into the district court, we will deal in the district court with those issues that come up. What our position here is, we have a jury trial right, and it needs to be remedied now, because going forward in the bankruptcy court could have preclusive effects on the other actions. Okay? Not just evidentiary, legal arguments, holdings. Okay? This is part of a pattern or practice. That's what their claim is, that you petitioners have engaged in a pattern or practice. And you know how we know this? Because you did it in that other case that we just filed against you, and you did it in that other case, and that other case, and that other case. So the evidence that's going to come out in one single case is going to be relevant. We already know it will, because they said it's going to be. It's going to support their claim. So the idea that, well, we could vacate the trial and then you appeal it to the district court, and we already know the district court has ruled that we don't have a jury trial right, so we'll go through that appeal and we'll end up here anyway.
Just help me with one more thing, at least for me. Are you saying that, say you do go to district court and you're having your trial there, the lawyers in the other 7 bankruptcy cases wouldn't be able to use the testimony gathered there, the discovery gathered there, in that preclusive way that you're worried about, simply because you're in district court?
No, they absolutely couldn't, the other adversaries. They absolutely could.
So I'm just trying to understand, why is the harm you're concerned about different if you're in bankruptcy court versus district court?
The harm in itself is what happens if you don't get into the court that you're entitled to be in. Okay? So you're right. Rulings by the district court in one trial are going to have the same preclusive effect or potentially preclusive effect as if the trial is conducted in the bankruptcy court. But if we have a jury trial right, the law's unambiguous. It gets withdrawn now, okay, under 28 U.S.C. 157E and under Local Rule 9015. So we would then have a right? We're talking about the first factor.
No, I know, but I know you're going to have a right, but that doesn't mean that the very first thing that happens is that a jury is impaneled.
Of course not, Your Honor.
Right? You're going to go through all that discovery, you're going to have all the pretrial rulings, et cetera, and right? I mean, all that. That's what you're talking about. That's what you're worried about in the bankruptcy court.
It's not a worry, Your Honor. We would prefer to be in the district court right now, and we have a right to. The
Okay.
first test of Cheney presumes, right? It comes first, but talking about it, okay, let's say you're right. You have this clear and indisputable right to a jury trial. We know under 28 U.S.C. 157E, if we don't consent to it being in the bankruptcy court, it can get withdrawn. The reference can be withdrawn. And we know under Local Rule 9015 that if that's the case, it gets withdrawn now. Now, some jurisdictions don't require that, but this one does. So we would have an immediate right for it to be in the district court. And then all those preclusive effects, whether it's evidentiary or legal rulings that the lower court, it become very important. Okay? It's not insignificant that you have a right to get out of the bankruptcy court if these conditions are met.
Okay, we understand your position. We'll give you some rebuttal time. Don't worry about the fact that the red light went on. Let's hear, though, from the Trustees Council, Mr. Aguiar, who's here remotely. Good morning.
Good morning. May it please the court, Daniel Aguilar for the U.S. Trustee. So I think just starting from where the court's discussion just took off from, I think applying this court's decisions in Caldwell-Baker and First National Bank of Waukesha, mandamus is clearly inappropriate under that second of the Cheney factors, in that you're going to be able to handle the merits of the claims and provide relief on a final judgment and on appellate review. What Bank of Waukesha recognizes that mandamus might be appropriate where they said there is a, quote, foreclosure of review, where there are going to be some issues necessarily that aren't going to be reviewable on an appeal from a final judgment. And what counsel and I think the court have discussed here, and what's at page 11 of their mandamus petition, is the claim that there's going to be issue preclusion on issues of facts in related cases about whether or not this is upright law's pattern and practice of procedure. That's not the kind of thing that's going to be subject to an issue preclusion or issue estoppel that's not going to be reviewable on an appeal from a final judgment. If the court, again, right now, let's just assume that there is a Seventh Amendment jury trial right. If the court determines that there is, on appeal from a final judgment, that's going to affect any factual finding in any case to which that would apply. And therefore, there would be a remedy that would flow from that. And that's why this is the kind of claim, as this court said time and again in Bank of Waukesha and Caldwell-Baker, that this is reviewable from final judgment. And simply invoking the claim that I have a right to a jury trial is not sufficient in and of itself to warrant mandamus. That mandamus
If you focus on the Cheney first factor,
sure.
And we
and
take...
so just as,
go ahead.
Oh, just as Your Honor was asking, I'm not aware of any case that holds that there is a right to a jury trial for these 526 civil monetary penalty proceedings. And I think the district court, applying the proper inquiry in Atlas Roofing and Grand Financiera and this court's decision in Ray Hallahan, the best reading of the Seventh Amendment case law is that there is no jury trial right here. That this is, even assuming that it's a legal claim, that it's one that's presented in bankruptcy, in public rights, that Congress is allowed to regulate and amend, and essentially, governing the practice of attorneys in front of the bankruptcy court. And those are historically things that are done without juries. And just going to the public right nature of this, right, I think that's best captured by the Supreme Court's decision in Milovets discussing these 2005 amendments to the Bankruptcy Code, where the court explained that these were amendments Congress passed to regulate the practice of debt relief agencies in order to correct perceived abuses. And so what happens is they impose statutory obligations on these debt relief agencies, saying, you can't misrepresent anything that you give to these clients, and that if you say that you're going to perform a service, you need to do that. That's 526A1. And so those are public rights that Congress created as it's allowed to do. And what Grand Financiera says, too, is that Congress is, of course, free to create causes of action, even if they're closely analogous to what might have existed at the common law, so long as they're consistent with the statutory framework and flow from Congress's Article I powers, right, the ability to regulate immigration or interstate commerce, or here clearly bankruptcy. Those are going to be public rights. And so here you have an adjudication of, is this debt relief agency complying with its statutory obligations? And if it's not, what kind of remedies are warranted? Clearly, there are equitable remedies that can be imposed in injunctions or the return of attorney's fees. But then Congress also said, we think in order to deter statutory violations, it is worthwhile to allow bankruptcy court to be able to impose civil penalties.
How do you deal with the language in Grand Financiera and Atlas Roofing that talks about incompatibility, and in Grand Financiera specifically about exclusivity?
Yeah, so I think Grand Financiera's procedural posture is pretty informative here, right? Because there, the claim that said, we think this is a fraudulent conveyance, right, that was filed in district court, where obviously in district court you have a right to a jury trial. This, I think, was even before the statute that allows for juries in the bankruptcy proceeding in 157 was enacted, right? And then the district court took that complaint and referred it to the bankruptcy proceeding. And now, if the mere fact that the initial complaint was filed in district court, if that alone could be dispositive, I think Grand Financiera is a much shorter opinion. It just says, this is United States versus Toll, you filed it in district court, so it doesn't matter about public rights because you just get a jury. But that's not the analysis that Grand Financiera went through. It said, this is really part of the bankruptcy claim here. And then that's why we have to do this detailed analysis, because this is historically a forum where we don't have jury trials. So we need to go through that analysis of, is this a private right? Is this a public right? And I think then you map onto that this court's decision in Ray Hallahan, where it said, arguably, and then that's not a mandamus proceeding, right? In Ray Hallahan is an appeal from a final judgment, just further going to show that even in jury trial claim theory, that's the kind of thing that you can remedy on that final appeal. In Ray Hallahan said, well, you're claiming that this is a legal claim, that it's a breach of contract claim. Assume that that's true. Nevertheless, it's being raised by you as you are the one who has invoked the bankruptcy court's jurisdiction. And so you are trying to essentially have your cake and eat it too. You're trying to enjoy the benefits of the bankruptcy court, which historically has operated without jury trials, and to get all of its benefits. And simultaneously, you're saying that you want a jury trial that's incompatible with it. And what N. Ray Hallahan has said is that even on de novo review, there's no Seventh Amendment right there, and that kind of claim can be adjudicated without a jury. And so I think applying the best reading of all those line of cases, you have here a debt relief agency that prepares and files a bankruptcy petition on behalf of debtors, being able to claim attorney's fees for that, invoking the bankruptcy court's jurisdiction, and subjecting itself to the statutory obligations that Congress enacted in Section 526. And then when there's alleged to be a violation of those statutory obligations, saying, well, I want a jury trial now, even though I've enjoyed all of the benefits of the bankruptcy court system here. So I think both the best reading of these cases and how the Seventh Amendment has been understood and applied is that there's not a jury trial right, but at a minimum, petitioner has not demonstrated a clear and indisputable right to relief that would even satisfy the first prong of mandamus.
If you focus on the Cheney factor about other avenues for relief, whether it's Cheney 1 or 2, don't worry about the order, but the availability of appeal, and we take our decisions in First National Bank of Waukesha and Coldwell Baker as good law, you see any possible way for relief to be granted?
I do not.
Mandamus relief?
I do not. This is traditionally the kind of thing you have to wait until there's a final judgment and then appeal.
So is that, in the trustee's view then, is that saying that the Dairy Queen line of argument is foreclosed entirely by circuit precedent as well?
I don't think it's foreclosed. I think Bank of Waukesha took this pretty seriously and discussed those factors at length. And I think what it said is Dairy Queen and, apologize, I'm forgetting the other case, those are really drawing on this other rationale that is about foreclosure, issue preclusion, and being unable to actually get meaningful appellate review at the back end. And that's why those cases still have merit when they apply. But for the reasons that we were discussing, that there's nothing here that's actually going to be issue preclusive, that's going to be able to escape appellate review. That's why the proper recourse is an appeal from a final judgment.
Okay.
I'm happy to answer any other questions.
What role do you think consent plays in this, if any? The consent that's embodied in the what is it, 157E? Does that have any relevance whatsoever in the substance of the Seventh Amendment merits analysis?
On being able to obtain the jury trial in the bankruptcy proceedings, I read 157E as essentially, I think there, if I'm remembering the history here correctly, there was a series of follow-on cases from Gran Financiera essentially saying, we know now that for certain legal claims involving private rights, those have to have juries out of bankruptcy proceedings. Does that mean that you have to have the jury in the bankruptcy court or the district court? And then at a time, the statutory authority was less clear, and there was a division of authority among the courts of appeals. I think this court came down on the side of the statutory authority is not clear. It has to be the district court that holds a jury trial. And so then Congress amended the statute to make it clear that in the bankruptcy court, you could have the jury too, to sort of have those claims. And so it sort of presupposes that initially there is a right to a jury trial under the Seventh Amendment, and then you have the statutory authority to flow onto it. I don't read the statute as saying that even if there isn't a right to a jury trial, necessarily you can get one in through the back door.
Let me just ask you, petitioners filed a motion for leave to file notice of supplemental facts. They wanted us to take notice of the fact that the trustee began filing motions to examine attorney's fees in several of the underlying bankruptcy cases we've referred to here, which goes to their concern that they're on the road to a 526 claim in a bunch of these other cases too. What's your response to that motion?
Sure. So I don't think that that's relevant to the analysis here. And even if it is, I think it supports us. So first off, I don't think any of these cases say that just because you might have to try many more cases, that means that you have a greater right. Essentially, that would be saying that if you're alleged to be a malfeasor one time, you don't get a jury trial right. But if you're alleged to be a malfeasor in many cases, then all of a sudden you do. But just as to the status of those cases, there are currently 7 adversarial proceedings in which I think either the trustee or the bankruptcy court has inquired into whether or not there should be a 526 penalty. In 13 cases, the United States trustee has concluded its investigation and determined that the bankruptcy case should be closed with no further inquiry into whether a 526 penalty is appropriate. And there are a number of other cases in which the United States trustee has said under a separate statutory provision, I believe it's 11 U.S.C. 329, that potentially attorney's fees might need to be clawed back. That's an equitable remedy and doesn't implicate the 7th Amendment at all. And so I think at most currently, there would be 7 cases in which you'd have to have some sort of a hearing in order to adjudicate whether or not a 526 penalty is appropriate. And as Bank of Waukesha made clear, I think it's on page 1006, if you have an error and you have to redo a potential trial, that's something that occurs for a lot of potential of reversible errors. But that doesn't necessitate that you grant mandamus in this sort of interlocutory posture by claiming that that's sort of an unbearable burden.
Mr. Aguilar, can you go back on I want to make sure that I understand your position again. Can you restate it on the issue of the grand financiera and the kind of Atlas roofing language about looking at whether focusing on whether juries are incompatible with what's happening in the non-Article 3 tribunal, or whether there's a resolution, you're in a resolution tribunal that is exclusive of juries that way? I mean, how do you read that language and reconcile it with your position?
Sure. So I read that language as historically noting that in administrative proceedings or in grand financiera, that there aren't going to be jury trials. For example, I can't remember whether it's the Department of Labor that's at issue in Atlas Roofing and saying you're not going to have a jury trial there most likely. There's nothing that statutorily or constitutionally prohibits an agency there, the Department of Labor, or you could imagine another one, impaneling an advisory jury. Pulling in other people from the agency or from the street and saying, please help out the secretary as, she tries to. So
you think Atlas Roofing comes out the same way? Atlas Roofing comes out the same way if the commission, the OSHA commission, was able to resolve that by jury?
I think what they're saying is that historically, this has been an agency or administrative tribunal where we don't have juries, right? Because that first step is saying, what would have existed at common law, separating the courts of law from equity. At law, traditionally, there were juries, and when the courts had inequity, traditionally there weren't. But obviously, if you I can't remember whether there were any explicit prohibitions on it, but I don't think the logic changes if, for example, you had a court of equity who then impaneled an advisory jury. It would still be the court making all of the equitable findings and determining the equitable remedy, etc. But it was saying, historically, we know that you're not likely to get a jury in that scenario, and therefore no jury trial right attaches. It only attaches when you are in that court of law. So when the district court's sitting in bankruptcy, historically, an equitable proceeding without a jury, that's why grand financiera's analysis proceeds the way it does, saying this is historically not a court at law, so how do we analyze the kind of right that's available here? It's a legal claim, now I understand, but it's in this equitable forum. Does it involve private rights or public rights? And goes through that analysis.
Okay, very, very well. Any closing comment, Mr. Aguilar? I don't know if you can see the clock, but you got about 30 seconds.
We ask the court to deny the petition. Thank you.
Okay, very well. Mr. Mendito, we'll give you about 3 minutes on rebuttal.
The existence of all these other motions and the other 8 adversaries, it distinguishes this case from First National Bank of Waukesha. That's the current posture of this case. The idea that the bankruptcy court might, or any reasonable bankruptcy court should, as Your Honor hypothesized, stay these matters doesn't change the fact that these are not stayed and they are going forward. Okay? And I think it's also relevant that what we're talking about here, who is the plaintiff in these cases? It's the Department of Justice. Now, I understand that a particular subcomponent of this one entity has initiated this proceedings, the Region 10 U.S. trustee. But petitioners, defendants like the petitioners, have no control over how much the Department of Justice chooses to just carve itself up to where it's, oh, this is just in our region. Well, there's just one bankruptcy judge. Well, she's probably just stay 8 proceedings. This is a national law firm. They're subject to regulation by the Department of Justice in every jurisdiction where they practice. Okay? The fact that this trustee might be stayed in 8 different adversary proceedings doesn't mean the Department of Justice is not stayed. Okay? They keep pointing to other cases where they brought actions against this law firm, and they know it's a small percentage of the cases that have been filed. But upright law and petitioners like and individual attorneys like Jim Ford, they can be subject to other actions by the Department of Justice. Okay? So the existence of these and the existence of these motions to examine that can also be amended to have a 526 claim, it just doesn't end. When we filed this, there were only 7 adversaries. Now there's 8. Another one got filed, and while we've got several cases up on appeal where the 7th Circuit is considering a jurisdictional issue, they filed more actions in those cases that are currently before the 7th Circuit, and maybe that other panel will take issue with it. Okay? But the possibility of more actions and the preclusive effect of them is significant here. And one of the things that I think Mr. Aguilar talked about was issue preclusion, right? And Your Honor said, well, what if they reversed an application of issue preclusion or collateral estoppel? Well, that would just be reversing the application of that standard. It wouldn't change the facts of what came out in a case, okay? Because issue preclusion talks about, was there a final judgment? Was it essentially the same parties? Was it fully litigated?
If you win on appeal, the judgment's vacated. Wholesale.
That's if the judgment is vacated, but that doesn't change the fact that all the pretrial work would have gone through in the forum that we were allowed to be out of, that it wasn't in the district court. The idea that, well,
do you know of support for the proposition you're advancing that when a judgment, root and branch, is vacated because the party's 7th Amendment rights were violated, that pretrial rulings nonetheless can have preclusive effect? What authority supports that?
Your Honor, the evidence, I'm not aware of any authority on that right now.
Okay. No, go ahead. Finish your thought.
No, I don't have any authority on that. I think we can look at what's going on in the case and see the significance of what the impact of those adverse rulings would be, okay, on the other cases. The mere fact that someone says, oh, you shouldn't have had you shouldn't have had to do that deposition in the bankruptcy court doesn't change the fact that the deposition took place, or that someone would later say you shouldn't have had to testify on that subject matter. It doesn't mean that it didn't occur, and that discovery or that record evidence could still have a preclusive effect in other trials in a different forum when it comes up, when someone maybe takes a contrary position, or an admission or a piece of evidence might be used for some other purpose.
Okay, thank you. We understand your position. Mr. Aguilar, thanks to you as well. We'll take the case under advisement.
Thank you, Your Honor.
We'll move to our third case of the morning. There's multiple appeals numbers here, but the lead appeal number is 22-1743. Richard Mazurek versus Metalcraft of Mayville. And Mr. Krukowski, good morning to you. We'll hear from you.
Again, good morning. May it please the court, my name is Tom Krukowski, and I represent Metalcraft, the appellant here. This court's decision in re TCI, I think, summarizes our argument here when this court said, quote, "It's easy to start, suits are easy to start, hard to defend. The best way to control unjustified litigation tactics is to have those that cause those tactics that create the cost should bear them." By introduction, let me just say that this case started on October 17, 2017, over 5 years ago with 1,000 employees. It was a class action and a collective action under 16B and Rule 23 that was dismissed voluntarily after we filed and served the safe harbor letter. Immediately thereafter, the plaintiffs and their lawyers filed 25 what we consider to be baseless lawsuits. As a matter of fact, the district court, referring to these filings, said they were filed in almost every district court within the Eastern District of Wisconsin, all 25. Furthermore, the district court refers to them as tribble, so, a comment out of Star Wars. 9 plaintiffs were forced to dismiss their lawsuits for lack of prosecution of the reasons, which remained 16 cases that started the ball rolling for the what I would characterize as being the scorched earth tactics used by the plaintiffs with the attitude of damn their torpedoes, full speed ahead. Hawks Quindell, the law firm representing all these plaintiffs, had over 30 months during the class action proceedings to do discovery before they then filed the 25 individual lawsuits, 9 of which were dismissed, 16 of which survived, 16 of which are pending before this court. And what was established during that 30 months, which was extensive discovery and more discovery, after the filing of individual lawsuits, another 21 months or 51 months, the district court, in evaluating this case, had to figure out how he was going to deal with 16 cases. So he gave both the plaintiff 2 cases and the defendant 2 cases and said, you tell me what your case is all about and see if you can win summary judgment. Upon submitting summary judgments, both the plaintiffs and defendants, the court said all 4 cases are dismissed, even though the defendant didn't file a motion for dismissal or summary judgment on their cases, saying that plaintiffs can only muster speculation and guesswork to prove their claims. And it went on. We filed for sanctions under Rule 11. Rule 11 sets the ground rules for litigation, and we feel those rules have been violated. We think there's been abuse of discretion here. We're also saying that the deference to the district court is missing for 3 reasons. One is there's no way for this district court to find that there was a certification, or could the plaintiff certify in any one of these 16 cases that they had evidence or was well grounded on evidence or had evidentiary support. Secondly, there wasn't a smidgen of pre-trial investigation in any of these cases, and we'll discuss that. And third, and that was ignored by the judge in the district court in denial of sanctions. Thirdly, the district court ignores that the scorched earth tactics of the plaintiffs was a prohibition under Rule 11, again, the ground rules for litigation and the cost. In terms of abuse of discretion and the lack of deference is found in the cryptic comments by the district court judge when he says, number 1, he says, plaintiffs already lost, sanctions be an overkill. And our motions for sanctions was petty bickering. First off, with regard to the already lost, and as far as the concern for overkill, that's a non sequitur, because it doesn't follow. It's the very fact that the 16 cases were dismissed because they were baseless, and no sympathy for the dismissal. But more importantly, what the court does with that statement, it eviscerates all of Rule 11, or at least ignores Rule 11, and the fact that it sets the ground rules for how we should litigate cases in the federal court system. Overkill is also another overstatement or misplaced. The only overkill here was the scorched earth tactics of the plaintiffs in litigating the case, and Metalcraft having to endure the continued defense of its innocence. We say erroneous view of the facts and law. The denial of sanctions was an abuse of discretion because there's 6 layers of frivolity in this case. Any one layer is sufficient to find sanctions. 1, abuse of, there's no admissible evidence under 602. Plaintiffs shift their emphasis onto 406 or routine. There was none. No pre-filing investigation. 4, unnecessary increase in litigation, a prohibition of Rule 11. No possible claim under the Portal Act, an amendment to the Fair Labor Standards Act. No possible claim under the de minimis doctrine. Number one, no admissible evidence. The district court, and when we're referring to this, we're not talking about submitting to the court testimony or depositions or transcripts or documents. We're saying these are findings that the district court made in the summary judgment proceeding. Quote, can only muster unreliable speculation and guesswork. Quote, no admissible evidence. Quote, cannot satisfy limited burden. Quote, not an open invitation to guess or invent work post hoc. Quote, no memories and no prospects of recovering them. Quote, in short, none of the four plaintiffs in this case has evidence to support their claims. You can't have it both ways. You can't say all what you just said, what the judge said, and then later on deny sanctions because there might be some facts.
Mr. Krakowski, can I ask you a question?
Sure.
I'm going to ask this of appellees. I'm completely with you that the standard under Rule 11 is certainly not plaintiffs have already lost, sanctions would be overkill. That is unequivocally not the standard. I read these two orders and I would have bet a lot of money that they were written by two different people. Okay, the summary judgment order. Now that the issue is the abuse of discretion standard, I think, for your client. But the question I have for you is procedurally in the Eastern District of Wisconsin, in most districts where you file related litigation, or you file 25 lawsuits, individual lawsuits against individual or against the same defendant, you have to notify the clerk that they're related. They all immediately then get assigned to the same judge, even though they're 25 different pieces of litigation. It's not what happened here. And I'd like you to comment on that and why. I mean, it seems to me that perhaps the plaintiff was looking for perhaps the best judge that they could find for their case in the Eastern District of Wisconsin, but maybe that wasn't the case. How did this shotgun approach work?
Well, because it lends itself to the fourth element I said before, the unnecessary increase in litigation costs.
No, I'm saying procedurally, how did they get in front of all these different judges in the Eastern District of Wisconsin? And then Judge Ludwig said, well, wait a minute, they're all going to come to me and I'm going to consolidate them for discovery. Why were they not all originally assigned to the same district court judge?
I can't answer that question. I'm not the plaintiff's counsel, but they basically filed every individual lawsuit, all 25 lawsuits. And they, under the clerk's procedure, then were assigned to 25, the 25 cases were assigned to as practically every judge in the Eastern District.
Were they filed at the same time?
Yes.
And is there any requirement in the Eastern District, in the local rules in the Eastern District of Wisconsin, that you notify the clerk that they're related litigation?
I'm not aware of any that specifically required the plaintiffs in this case to make that motion or consolidate. It'd be a separate, distinct motion to consolidate these cases, which the judge did it on his own. After the judge had heard us complaining, sua sponte, he just says, okay, stop. I'm not going to deal with this anymore. We're going to consolidate all these cases, to which we said thank you, and agreed with him in terms of now we could isolate the issues, particularly for summary judgment, and it's how we dealt with it. When we're dealing with this issue of evidence, no evidence for the judge's evaluation, what he ignored, take the case of Richard Mazurek, the lead plaintiff in this case. He testifies in his deposition. His lawyer, to try to rehabilitate him in the deposition, says, Mr. Mazurek, why do you continually use the word speculation, guesswork, and conjecture in answer to the company's questions? Mazurek answers, because I have no proof. Then the lawyer puts the last nail in the coffin when he says, specifically to rehabilitate the witness, he says, quote, and when you say you have no proof, are you talking about you don't have any written proof? Then Mazurek then closes the coffin when he says, written, verbal, any kind of picture, nothing. Let me repeat that. Written, verbal, any kind of picture, nothing. A lawyer sitting through that deposition and 3 months later signing and filing a complaint and saying there's a claim, a false claim? There's no way to certify. It's impossible to certify a claim when your client's already told you on earth they have no proof.
But you're not objecting that a plaintiff can't rely on reconstructed memories to bring an FLSA suit when an employer's timekeeping records are at issue.
Correct. That's the Espin case that the court relies upon in denying sanctions. So the court's basically saying, as far as they're concerned, we'll deal with those issues. So the court says, to your point, you can reconstruct or you can construct work time by memories. And also in the Brown case, he relies upon denying sanctions. You can do it through triggering factors. But what the district court denies, or completely ignores, is this. He says, quote, each plaintiff also rules out the possibility of triggering factors. Quote, with no access to memories and no prospect of recovering them, plaintiffs can offer nothing more than their bare allegations. That's 180 degrees. Opposite of what the law provides for. It shows in terms of the issue here that we're talking about, it basically grounds for reversal. It's an erroneous view of the law because you have to have a memory, and he says you have none, no way to reconstruct it. And he said there's no triggering factors in the Brown. So therefore, we have erroneous view of the law.
Well, let me ask you about another ground you think is amenable to sanctions. It's this portal-to-portal arguments, de minimis arguments. I mean, I looked at the summary judgment briefing. Plaintiffs spend a lot of pages distinguishing the portal-to-portal cases and the de minimis cases and trying to show why their situation is distinguished from the precedent that you're relying on. That's argument. That's legal argument. Why is that frivolous? Why is an argument trying to distinguish yourself from precedent that other people think dooms you? How is that sanctionable?
No facts to dispute. There's no facts as to what if these people could have performed some preactive activity before employment. And the court said it in its decision, which was not appealed, you didn't. You didn't have any evidence to support your position with regard to the Portal Act.
That was a footnote.
It was a
footnote. The court spent a great deal of its order looking at your other sanction issues.
Agreed.
Would it be reasonable to conclude that if the court had come out the other way on the substance it spent time on, it might have spent more time on this portal-to-portal and de minimis stuff?
I don't think he had to. He's looking for an afterthought. He's saying, after all of this, what I've just told you, in terms of no admissible evidence, et cetera, he's saying, furthermore, you can't even bring a case because of the Portal Act and de minimis. He's taken the ribbon and putting it around the package and saying, as far as I'm concerned, there's no way you can have a case here under any set of circumstances, which gives us another layer of frivolity. And whether it's a footnote or it's not a footnote, it is the judge's decision for which the plaintiffs have not appealed, and basically becomes a decision of the court. Now,
Mr. Krukowski, what do you think the best authority is in the case law for your position? And the reason I ask you that question is, as you well know, there is a lot of litigation that is brought that fails on the basis of just very, very substantial shortcomings in evidence, and raises, summary judgment is entered. There's all kinds of opinions that say this claim, there's just no evidence to support it, right? And you would think, well, we should be able to go to our case law and find loads and loads of Rule 11 sanctions opinions. You really can't.
But there are quite a few decisions discussing it. To your question, by the way, I'm trying to reserve some time for my rebuttal. Do I have some?
Well, yeah, go ahead.
Okay, thank you. It starts with a Cooter Supreme Court decision where Senator O'Connor is saying, okay, fine. If you violate Rule 11, these are the consequences of violating Rule 11, and it's obviously what we're asking for here in terms of deterrence and in terms of restitution. Then we have this court's decision in Szabo. Then we have this court's decision in Tennessee. Then we had the Supreme Court's decision in many different cases cited in our brief in terms of...
Szabo is totally different, though. Szabo is a situation where the court, like in a sentence or a half a sentence, says, I don't think Rule 11 sanctions are warranted. You say, well, but here you have a reasoned order. I mean, I know you don't agree with the reasons, but Judge Ludwig did. He wrote it down, he explained it.
But he's in the context of Szabo. Szabo's given us what the law is. And what Jesus Brooks is writing about it there is he's saying to us, he says, look, if you're going to violate the law, you got to expect to pay. If you're going to violate the ground rules of Rule 11, you got to expect to pay. That's the point of Szabo. But all the other cases that support this position are also cited in their brief and sit back and say, we can deal with it. We can deal with it. But if you violate this rule, the ground rules of litigation, you should expect to pay. Now, a few words on the issue of preclusion, which I heard you discussing in your prior case, where the plaintiffs in this case, in the context of the Rule 56, say there's no pro-plaintiff evidence, there's no pro-plaintiff inferences. That finding of the district court at admission is what binds the court, Rule 56, and Rule 11. and this court's decision in Amtrak also supports the position that, look, when you've got ancillary proceedings in both the Supreme Court's case and the Coder case and in the Zabel case, that these proceedings are collateral, but it doesn't stop the process. You don't eliminate preclusion, whether it's issue preclusion or whether it's a law of the case. The court is sitting back and saying, you're stopped from raising that issue. And Judge Posner in his decision articulates and says both law of the case and collateral estoppel are flexible doctrines and classifications and need not be critical. Why? Because all we care about, we don't reopen them. We don't relitigate. All that what the judge said is binding in the subsequent proceeding or our proceeding in terms of Rule 11.
Okay, why don't let's go to Mr. Vesio. We'll give you a couple minutes on rebuttal.
I appreciate it. Thank you.
Thank you, Your Honor. This case is mostly about the standard of review. In a Rule 11 sanctions ruling, it's an exercise of judicial discretion, and unless the judge abuses that discretion, the judge makes the decision and the Court of Appeals doesn't reverse it because the Court of Appeals would make a different decision. It's a matter of the institutional prerogatives of the district court. That point is made in the Cooter and Gell versus Hartmark's case, 496 U.S. 384 at 402. The district court is familiar with the issues and the litigants. The district court is better situated than the Court of Appeals to decide that issue. That's what happened in this case. The district court made the ruling on summary judgment based on its summary judgment analysis, and we haven't challenged that on appeal, so that's not a subject for the challenge. And then the district court had the judgment call after that, when presented with the Rule 11 motions, to decide whether the case was, even though it came up short on summary judgment, the kind of case that lacked good faith and therefore merited Rule 11 sanctions. And essentially, the district court is in a better position to discern good faith and bad faith because the district court judge spends a few minutes with the litigants on multiple occasions and is face-to-face with the litigants. And this judge decided in its Rule 11 decision that there was no bad faith. The judge specifically said in his decision all of the briefs were tied by citation to the factual record. And as I've pointed out on brief in both levels, the district court and the Court of Appeals, the real question in this case was not whether there was evidence or not. Both parties worked from the same evidence. No party said that some of that evidence was a lie or a deceit or something like that. They both just drew different inferences from that evidence. And the question for the district court on summary judgment was, are those inferences reasonable inferences that are being proffered by the plaintiffs, or are they not jury worthy because they don't constitute, as a matter of law, reasonable inferences worthy of a triable issue?
Do you think, I don't know about that. I read the summary judgment opinion as going further than that, as basically this is baseless. There is nothing to support these claims.
It did.
So that's different than, debates about inferences and what have you.
It did say that
there's a lot of pretty sharp language in the summary judgment order.
That is true, and the case was characterized by that judge as being a weak case, but the judge did acknowledge that there was some evidence in the record that might support an FLSA case if that evidence was not contradicted by all the other evidence in the case. And that's why the judge made the ruling on summary judgment that the facts did not support that position. But
I didn't read that in there. I read, what I'm concerned about is, now you have an abuse of discretion standard, okay, which is a very high standard. I agree with you. This case is about abuse of discretion. But what I read the district court saying in the summary judgment brief, and maybe you can tell me where the district court says there are facts, because he says handful of facts, but I don't see any description of them. He says this case is based on speculation and guesswork. And that first paragraph is really bad for your client. I mean, it's really bad. But then he issues the sanctions order, and he says, let me read it, plaintiffs have clearly lost, sanctions would be overkill. That is not the Rule 11 test. It's just not, okay? So the question is, can we look to the record and find facts that support the district court's handful of facts, so it's not abuse of discretion. But what facts are there? I mean, your client filed a lawsuit, an FLSA lawsuit, for a plaintiff that worked for 2 weeks and never worked for 40 hours in either week. I mean, that is pretty bad conduct. Now, they dismissed it, but boy, that, you think about a lack of pre-filing investigation. It doesn't get much worse than that.
Counsel, I don't agree that there was a lack of pre-filing investigation.
I understand. I'm not asking you to agree with that.
But counsel has mentioned the Mazurek case as sort of the lead plaintiff case in his oral argument. And Mazurek does say that he doesn't have any proof to support his claims. But if you think about it, the word proof is a lawyer term. It's a term he might not have understood and didn't understand what proof meant. If you took his entire testimony, which is in the record, take his entire testimony in totality, as a layperson, what he thought was non-proof was really evidence itself. It was his testimony when he reflected on his memory, trying to recall what had happened. Remember, this is occurring in a informational vacuum that was created by Metalcraft, because Metalcraft didn't keep a time system that recorded accurately what its employees did. And so in that relaxed circumstance, we had a lower threshold for the evidence that we had to submit.
Yeah,
now, I agree, we didn't, according to the district court judge, we didn't meet that threshold.
Your client didn't help itself very much when it submitted its damages spreadsheet. I'm not sure that is, I'm not sure that carries the day for the appellant here, but certainly didn't help itself when you submit a damages spreadsheet that is absolutely contradicted by all the facts in the evidence.
But Mr. Mazurek did testify that for about 14 minutes on a routine basis, each scheduled shift, he was there and he was obtaining tools or getting direction from his employer. That was the evidence that we believed when we filed this lawsuit and when we maintained the lawsuit, that the court could take as the lower quantum of evidence that it needs in the presence of this time system for the court to be able to make reasonable inferences and therefore subject it to a jury as a triable issue, that there were reasonable inferences that the court could draw. What we didn't agree with the court on, what we failed, according to the court's decision in the summary judgment motion, is the reasonableness of our inferences. We decided, or we believed, that we could submit reasonable inferences for the court, and the court disagreed with those reasonable inferences. That's a matter of law. Whether the court thinks those are triable issues or not is a matter of law. And the court disagreed with us on that. It's not that we lacked any facts. We were citing facts for every fact we used in our briefing. We did a record citation. We did what conscientious lawyers do. We did what advocates do. We made something of our client's case that might not have been there for an objective observer, but we're zealous advocates who are representing our clients, and if there's any argument that supports our clients, we have to make that argument, and we have to give the testimony in the character that best supports our client's case. And we fell short. So then the question became, in the Rule 11 proceedings, if that falling short was so terrible that it warranted sanctions, that it was so egregious that sanctions should be awarded. And in a Rule 11 case, the courts have to be concerned with putting a chill on the advocacy of attorneys by saying to an attorney, you're going to be sanctioned under Rule 11 unless you can prevail in the case. And that will put a chill on litigants' access to the courts, and that's ultimately a very big problem under federal law and constitutional law. And so the court has to be very careful not to chill a litigant who is bringing a case that may not ultimately prevail in a summary judgment motion or in a trial. The other thing that this case is about is about the meaning or a fundamental misconception of what the difference between summary judgment is and what a Rule 11 sanctions determination is. If a party lacks the facts to get to trial, the facts to get past summary judgment, my counterpart contends that means essentially automatically that the case was not based on any evidence at all, and it's not grounded on evidence, then Rule 11 sanctions must apply. But I meant what I said on brief in this case. Zero pro-plaintiff evidence and zero pro-plaintiff inferences are the prerequisite for losing a summary judgment motion. So if it were true that you have zero pro-plaintiff inferences and zero pro-plaintiff evidence, if it was true that if that happens, then you've got a Rule 11 sanctions case, then every single summary judgment motion anybody ever stood defeated on, at least on a factual issue, would then warrant Rule 11 sanctions. Well, that's not the law in the Seventh Circuit. The law in the Seventh Circuit is that a summary judgment defeat is not an automatic loss on a Rule 11 motion. And so there is a territory in between those two places where you can lose a summary judgment motion, but you made good arguments, you made arguable issues out of the case, and therefore you don't get Rule 11 sanctions. And who do we allow to make those decisions under the discretionary standard? We allow the federal district court to make the decision, make the judgment call as to whether a summary judgment motion that fell short also falls short of the Rule 11 standard. And that is a judgment call under the case law. And the district court judge made that judgment call in this case and should be affirmed on that basis. And again, I want to mention that this is a case in which the reason there's a lack of evidence is partly a function of decisions that were made by Metalcraft. Metalcraft made the decision to schedule work times and then operate its time system in a way that didn't make accurate depictions of what a worker actually worked in the field on a given day. And under the case law that's well established under the FLSA, that made the best evidence unavailable, and that's the Brown versus Family Dollar case, 534 F 3rd 593. And that means that the less than the best evidence had to take center stage in this case as a function of decisions made by Metalcraft. And that is a lowering of the standard on summary judgment that induced my clients to believe that they could come forward with less evidence than an ordinary litigant would have to with an accurate time frame and time accounting system, and that less than the best evidence would then be what it had to present on summary judgment. Unfortunately, Judge Ludwig disagreed, and the judge allowed, at least for Mazurek, quote, somewhere in this jumble there are a handful of facts that might support an FLSA action. What the federal district court judge was doing there is acknowledging that there were facts that supported the plaintiff's position. They just weren't going to carry the day because they didn't lead to reasonable inferences that made a triable issue for a jury question. And that's how the defeat occurred on summary judgment. But that doesn't mean that there weren't any facts that supported my client's position. In context, the court just deemed that the proffered inferences did not meet the reasonableness test. Courts determine reasonableness of inferences as a matter of law. And,
one thing that's difficult here is that the court could have said what you just said.
The court what?
The court could have said what you just said. It's reasonable inferences not supported here, et cetera, et cetera. There's some, but the court said somewhere there might be a handful. Not there is a handful. The court said somewhere in this pile there might be a handful. It's a different take on the case than you're presenting this morning.
Sure.
Which makes it a little more difficult here, matching the two.
And the court said that in the course of leading to us getting a defeat on summary judgment. When the court had the question of whether we had any facts at all to support us, the court referenced its previous acknowledgement that there were some facts in the record that would have supported our position. And so that is exactly the borderland between losing a summary judgment motion and being completely frivolous that the court properly acknowledged exists and properly found that we were residing in this case. And so that, yes, the court is going to characterize our case with a little more jaundice than I when it's leading to defeating our case. than it is when it's leading to a litigant prevailing in a case. That's just a natural consequence of the mission that the decision is on when it's aimed at that conclusion at the end. So, in the final analysis of this case, summary judgment defeat does not mean that you lose the Rule 11 motion that follows it. And this court adopted a reasonable procedure for determining whether there was going to be merit to any of the 16 cases that are at issue on appeal, and led with the first 4. That was a matter of its discretion. It was entitled to adopt that procedure, that reasonable procedure, in order to operate. And the court decided the 4 cases that placed the metaphorical writing on the wall, and so the plaintiffs conferred with their attorneys and decided to not proceed with the other 12 because the evidence would have been relatively the same, the inferences would have been relatively the same, and they didn't have a large expectation that, at least at the federal court level, they were going to get a better addressing of their case before the court.
Okay, very well. Thank you, Mr. Vescio. Mr. Krakowski, we'll give you 2 minutes.
Thank you. There's no evidence in this case. The judge says it over and over again. There's no admissible evidence. And this comment that you referred to might be something. It's obviously speculative in of itself and probably metaphysical because it's imaginary. There's nothing there to support your position. If you take that statement and anything else that summarily the judge says, if you take them whatever that is, which is nothing, it still comes down that you can't deny sanction based on a case that wasn't certified. You can't certify speculation. Speculation is not evidence. They cite the records, the company records, in terms of whatever that is. Under this court's decision, while records don't show anything, if you don't prove or have a memory of your working, you don't have a case. Not whether it be Kornowski in terms of working 2 weeks or the balance of it. Now, at least say all of this brings up the issue of, can you escape sanctions on Rule 11, the ground rules, by no certification of facts, no pre-filing investigations, not a smidgen, and basically unnecessary litigation, unnecessary cost litigation. 74 depositions, 125 documents, 253 interrogatories to prove what? Like the judge said, you can only muster speculation and guesswork. Furthermore, what you should be aware of is that in looking at this case and instructions to the district court, and hopefully on a remand, you're looking at it and saying, the lead counsel in this case, basically in the shrimp case, Judge Griesbach admonished this lawyer, saying you can't bring lawsuits in this court with speculation. But lo and behold, what he does, and what Hawks Quindell does, is they bring 25 basic costs of baseless lawsuits. Same thing. If the dismissal didn't occur, then obviously something more has to occur, and that's the restitution. If restitution is allowed here, we ask that this court reverse the judge on in terms of sanctions for the reasons stated, and that to give the court that the court give instructions regarding the effective deterrence as well as restitution. If that can happen, then we can say again, suits are easy to file, hard to defend, and the best way to control unjustified legal tactics is for those that create those costs, bear them. Thank you, Your Honor.
Thank you. We understand both sides' position. We'll take the case under advisement. Thanks to both parties. Move to our fourth argument of the morning in appeal number 22-1304, Ambassador Animal Hospital versus Alanko Animal Health. Mr. Bach, good morning, whenever you're ready. No, that's all right.
Honors. Philip Bach for the plaintiff. I've reserved 4 minutes for rebuttal. The district court erred by dismissing this action because plaintiff plausibly alleges that the faxes were sent to veterinarians to attend free dinner seminars were unsolicited advertisements within the definition of the TCPA. Congress intended the TCPA would prohibit unsolicited advertising by fax. In Physicians versus AS Medications, this court noted that the TCPA is a remedial statute and it must be liberally construed in favor of consumer protection. The definition here is the definition of unsolicited advertisement is any material advertising the commercial availability or quality of any property, goods, or services. In the Holtzman versus Terza case, this court construed that definition and noted that the content requirement is minimal. It's any content, any material that's advertising. And then the court ruled that context shows whether it was advertising, and the context there led the court to conclude that promotion or marketing was the reason the faxes were transmitted.
Mr. Bach, in a case like this, whether you're going to talk about it being a form of indirect advertising, or I'm not crazy about this word pretext, but if we want to insist on using it and we use it, what's the test? So let's assume that you prevail and one of us is drafting an opinion. How do you recommend we articulate the test? So we'll type out the definition, quote, unquote, and then how do we articulate the test?
The test for plaintiff to win?
The test for, no, the test for measuring what is an unsolicited advertisement.
Gotcha. Well, it would be a totality of the circumstances.
Right, what's the substance of it?
Any material that is advertising availability or quality of commercially available property, goods, or services.
So, but we ordinarily don't articulate a test by just repeating a statutory definition, right? That's what you just did.
Yeah,
you just paraphrased it.
All right, let's see.
The reason I'm asking that, I'll tell you why, is because your Coca-Cola example in your brief throws me off. Okay, and the reason that throws me off is I think, how in the world does that fit the statutory definition? And the way I understand your hypothetical is assume that the Jewel grocery store chain, its fax machine goes off with a fax from Coca-Cola, and the fax is nothing more than the Coca-Cola logo. That is it.
Yes.
How does that fit the statutory definition? And what that raises in my mind is, what test, or what's the principle in which that hypothetical fits the statute?
It's looking for a commercial purpose, commercial advertising purpose. The Coca-Cola, so like here, the Alanko is a registered trademark of Eli Lilly, and that's an advertisement. Now, it's not an advertisement in every context.
But okay, so the Coca-Cola fax, though, it has to advertise the commercial availability or quality, we can just say, of Coca-Cola products, right?
Yeah.
How does the logo itself does that?
Yeah, it does. It's a trademarked logo so that only that company can sell those products with that name. And so the name is synonymous with the products. Then it's more about the context in which the logo appears.
And you don't worry that empties the definition of limitations that are inherent in the language that Congress used?
I don't see the language as
advertising the commercial availability or quality. The only way that I can see that fits is you would say there's no way that Coca-Cola is going to send a fax to Jewel if Coke is no longer selling Coke products. It's not going to engage in just commercial futility. Right, Coca-Cola shuts down, for example. They're not going to send faxes after they shut their business down. Right, I mean, is that your point?
I don't know why Coca-Cola would send those, but if the example was Coca-Cola...
That's the example you offered, not me.
Well, that they sent it to a grocery store?
Well, or they sent it to somebody.
Yeah.
I mean, right, other than Walmart. They sent it to Walmart.
I don't
He
know
sent
why
it to
they
somebody.
would, but it could, the Goodyear blimp is advertising tires to people who know what Goodyear is. People who don't know what it is, they would just think that it's some guy named Goodyear or something. But people who know their Goodyear tires know now Goodyear is still in business, has enough money to pay for a blimp to fly around a football game. It's reminding you of Goodyear tires and their availability and their quality. And the less known, if I'm advertising something and nobody knows me and knows what I'm selling, I have to give a lot more words
Let me
and
ask you this.
descriptions than.
Let's assume that Pfizer, okay, in September of 2021, 1 month after the vaccine was approved, okay, let's suppose that it sends out to all hospitals and infectious disease doctors a fax, and the fax says the following: we're offering a free webinar tomorrow at 3 p.m. on preventing and treating COVID patients who are allergic to vaccines.
I think if I filed a lawsuit, they would say that they have a First Amendment right to
No.
say that.
Forget the First Amendment.
Okay.
Does it fit the statutory definition?
Is it about a vaccine that's for sale?
Treating COVID, the says show up at Buca de Beppo, okay, or go onto the webinar, whatever you want.
Okay.
And our seminar is about preventing and treating COVID in patients allergic to vaccines.
Okay. And who did they send that to?
All hospitals in the United States and all infectious disease experts and doctors.
And so yes, that would fit the definition of an advertisement under the statute.
How?
Because it contains material about Pfizer and what they're selling. And it doesn't have to hit you over the head to tell you that it's about something that's available and that it has a quality of goodness or preventing.
So what that risks then?
Reactions.
Okay, all right. So that if that's your position, what that risks is that Coca-Cola fax hypothetical goes to summary judgment 100% of the time. Because of commercial.
If it happened, it should, yeah. If Coke sends 5,000 faxes with just their logo, why should that case not be filed? What were they doing? That's why they sent it. It could be an accident or something. I don't know. They might have an excuse, but
right. But you agree it's a statutory case.
Yeah, but I mean the statute was written to regulate commercial speech, so it can't. The First Amendment says you can't regulate speech. Then the court said you can regulate commercial speech. This is commercial speech. They said what they're trying to do is prevent unsolicited fax advertising, not unsolicited fax advertising of a particular product name or something. It doesn't say name or price even. The statute doesn't say the price would be in an advertisement, even though that's some. I'm sorry, Aaron.
I'm surprised you haven't mentioned this 2006 FCC order, because you're being asked what's the test, what's the definition. Here we have a suggestion by the FCC of what would be the definitional hook in this case. It's a free seminar. Free seminars are advertisement, says the FCC. What's your take on whether we really ought to be asking, did the district court apply some sort of deference, make a deference finding about whether it should or not? That's something I'm struggling with here. What do you make of what the district court did here, particularly footnote 1 of her opinion? Did she conduct some sort of quick and fast deference analysis and say the outcome is the same either way? Or did she not? Should we be remanding for her to do that? Why isn't that something you're interested in?
The standard, we say we've alleged enough to plead a claim and she shouldn't have dismissed the claim under 12b6 for failing to state a claim. That's just Iqbal. She looked at the invitation and said that it was more likely than not that that's lawful conduct under Iqbal. That's when you can dismiss a case based on the pleadings, because it's impossible for this to have been an advertisement that fits the definition under the statute that says don't send advertisements by fax unless you get permission.
So in your view, she didn't consider the FCC's order at all? and how it defines advertisement, free seminars to mean to include advertising.
Yeah, I don't know if that, I don't know that she gave deference to the FCC, but I don't know that the FCC, maybe the FCC says all invitations to free seminars are advertisements, and maybe it doesn't, but I think what they're saying is that it makes sense that why does somebody give free stuff to somebody? Alanko is, why are they inviting a list of veterinarians to go to a seminar to get free food and free education credits and telling them to RSVP by registering with salespeople? And at the bottom there's something that says if you're a Minnesota veterinarian or work for the government, you might not be able to accept free stuff from industry people, so you can't get free food, drinks, and educational items, they say. So why are they doing this? And wouldn't that's what Holtzman versus Terza said is, why was he doing it? Now, he sent interesting information, but that was kind of a pretext, if you will, for advertising. He was reaching out. Here, they send even more interesting information. Not only is it interesting, it's free food and free CLE credits or CE credits, and it's from a company and a trademark name that is synonymous with veterinary products. You know, veterinarians would know. They sent it to veterinarians, so they knew who they were sending it to. And it's on this template, and it's just an anonymous invitation. And
Okay, we'll give you some time in rebuttal.
Okay, thank you.
Yep. Thank you, Mr. Bach. Mr. King, good morning.
Good morning, Your Honors. May it please the Court, Kevin King for the appellees. Judge Scudder, I'd like to start with your question about what is the test, and then work back from there to some of the other things the Court was discussing with Mr. Bach. The TCPA regulates the sending of unsolicited advertisements to fax machines, material that advertises the commercial availability or quality of property, goods, or services. And that statutory language contains three key limitations that work together to show that it's narrower than what plaintiff's giving credit for here. The statute does not, contrary to what Mr. Bach just said, regulate advertising in the abstract. Instead, it regulates a more specific kind of advertising. And specifically, first, the statute tells us that the fax needs to advertise goods or services, which is to say it needs to call attention to them to promote their sale. You can get that from the dictionary definitions on page 17 of our brief, or you can look to cases like the Third Circuit's Optum decision that adopts exactly that definition. Second, per this Court's decision in Terza, the fax needs to plug the commercial availability or quality of those goods and services, where you can buy them or why they're worth buying. It's got to be one of the two. Third, per section 227B1C of the statute, the advertisement needs to be sent to a fax machine, meaning that the advertising needs to appear on the face of the fax itself. You can't go out and draw that advertising from some other source, such as a later discussion at a seminar. The point here on this third one is that the advertising needs to go through the fax machine to count under the statutory definition. So when you put those three things together, Judge Scudder, you get a test. You get a test that says this statute's not looking to all advertising or even all unsolicited advertising. It's looking for a very specific type, that which promotes the sale of the defendant's goods and services.
What you're saying would make sense to me, but I struggle because we have this notion of Skidmore deference. You're saying the statute's non-ambiguous. It's not ambiguous. But then we also have this agency interpretation. And what is the district court's obligation? And did she meet it here? What's your view about whether she considered how the agency is actually now subsequently saying a piece of paper offering a free seminar is an advertisement? And so I want to ask you the same question I asked Mr. Bach. What's your take of what the district court did with this particular piece of information?
Yeah, my understanding, Your Honor, is that the judge looked at the statute and found that it's clear, and that's the same approach that a number of cases, whether you look at the PDR network decision on remand in the district court, the Pulse 8 decision from the District of Maryland, the Millennium Health case from the Eastern District of Pennsylvania, or the Third Circuit in Optum. Cases that apply the test from the Supreme Court in PDR network have almost universally come out and said that 2006 FCC discussion, I'm not really sure quite what to call it, is not binding, is not persuasive, because it does not engage with the statutory text. It does not discuss evidence or provide any kind of meaningful reasoning.
But she doesn't actually say that. You look at footnote 1, it's very, very short. She says, plaintiffs have made this argument, I should give deference to this order. The outcome is the same either way, full stop. Do we really have enough meat there to understand what the district court's analysis was there?
Your Honor, I think you certainly do, and that there are several reasons for that. One, this court in Terza had already declined to defer or give any weight at all to another part, a very closely related part of that very same FCC order. So this court's precedent had already said, look, that this FCC order is not going to be controlling. But beyond that, the Supreme Court had said, look, there are reasons why this isn't going to be controlling, and the Fourth Circuit looked at that on remand in PDR Network, and it said, and the United States, by the way, in its amicus brief, agreed. That 2006 order's discussion about unsolicited faxes, about this, free seminars, that's not controlling. It's at most an interpretive.
But before all those conclusions were made, the Fourth Circuit remanded to the district court in that case, we're talking about the same case, to conduct a deference analysis.
It did. There's no reason this court, if you're interested in squaring up to that issue, that this court can't do exactly what the district court in PDR Network did on remand and say this FCC order is entitled to no weight whatsoever. The Pulsate decision, Millennium Health, and the list goes on from there. So I think really, what we're focusing on here is a test that's prescribed by the statute. And the FCC order is maybe talking about, as in Terza, the Commission's enforcement priorities, perhaps. It's a little bit unclear. But Terza says, there's a discussion in this order, and then there's the CFR provisions, which are binding. This discussion is not in the CFR provisions. So I think when you're looking at this court's precedent, Your Honors, what you're seeing is the 2006 order is not really going to make a difference here. And so I guess if I could just come back to what we understand to be the correct test under the statute, it's those three things I was talking about: promoting the availability of the good or service, plugging its commercial availability, and making sure that the advertising you're looking at is on the face of the facts. When you do that here, we would submit that the judgment should be affirmed.
The notion of how this statutory definition deals with indirect forms of advertising. I really don't like this word pretext at all. I think it's more confusing than it is helpful to the law here. So I think these indirect, I was given Mr. Bach these hypothetical examples. So suppose we edit the example, the osteoarthritis example here, the facts.
Yeah.
And it's edited to say, come to the seminar, or you're invited to the seminar, and what's the topic of the seminar? Effective medications for managing osteoarthritis. How's that come out?
I think that comes out exactly the same way as this case did, Your Honor, because that fax doesn't mention the defendant's goods or services. It doesn't attempt to use the words of Optum from the Third Circuit to propose a transaction with the recipient. It may be advertising in some sort of general sense, but it's not the kind of advertising that this statute targets.
Okay, so
and I would add, of course, that that's not the facts that we're dealing with.
No, I get that. I know the line. So if we just switch that around a little bit, and you take that Pfizer hypo and you modify that, and you say effective vaccines, for preventing, or managing COVID. I don't think would you say at that point it still doesn't fit the statutory definition because it doesn't mention BioNTech?
It doesn't show the products, it doesn't mention the products, it doesn't do what the statute says it needs to do, which is to promote the commercial availability of those products, goods, and services. But I guess there's another piece that's lurking behind those questions, and that Mr. Bach got to, and I want to make sure I address. He's falling back consistently on commercial purpose. We know from the statutory context that commercial purpose cannot be enough. If you look at Section 227A4, the provision that deals with telemarketing calls, it keys liability to the caller's purpose, the purpose of the calls. The fax provision.
I think that's a fair point, but okay, let's set the purpose word aside. Okay, what if you say it can, though, account for the commercial context in which the recipient receives the fax? It's not purpose, like in where we're just drifting around talking about intent or something on the sender's part. It's focused on the recipient, not the sender. And you say we're gonna take a recipient and assume objectivity, and the recipients are infectious disease doctors or they're veterinarians or something. And so when they see Alanko or they see Pfizer, they know, they're drawing upon, you know, their knowledge to connect a dot that they're going to see is like it's like a centimeter apart.
Well, Your Honor, two responses to that. First off, the statute in Part D, it says the sender has to include its name and its contact information on the fax. So this notion Mr. Bach referred to about reminding the recipient of the defendant's products and services, that can't possibly be enough. And some of the judges on the Third Circuit, when they recently heard oral argument in the Millennium Health case, they pointed this out if you listen to that recording. But beyond that, the courts have said in National Imaging, in the Thalman case from the Northern District of Illinois, within this circuit and elsewhere, that the special knowledge on the part of the recipient, that's not part of the analysis. So I think you're right, Your Honor, it's an objective recipient test. It's not this particular recipient and what they know. I think that's a really a key point there. You heard from Mr. Bach, his test would make it so that if you just send your logo, that's enough, and that shows that goes too far. Precisely the concern the court was looking at in Optum, and precisely the concern that led them to draw a narrower test. You know, the liability in these cases can be massive, and if you adopt that capacious an approach, you make it so that companies can't do things like engage with their community. They can't do the kind of program, Your Honor, you were talking about with Pfizer, and engage with the community that they're a part of, lest they risk crushing TCPA liability here. So I think there's a real problem with the way, the sort of unbounded way that the plaintiff is going at this statute here. If I could just emphasize, I see my time is about up. The faxes here invited recipients to a free program that's certified to provide continuing education credit under Illinois law. It doesn't mention the defendant's products and services. It doesn't show them. It doesn't say anything about them at all. Instead, it refers to general topics of veterinary practice. That shows that it falls beyond the statute's carefully calibrated scope. Thank you, Your Honors. We would ask that the judgment be affirmed.
Okay, very well. Mr. Bach?
Quickly, Your Honor. The defendant's argument doesn't leave any room for indirect advertising. All there can be is advertising that specifically hits you over the head with the name and price, and the statute doesn't suggest that. It's broader than that, and the definition is broad in other contexts. It means commercial speech. He said that this would prevent Alanko from reaching out, but we don't know Alanko was reaching out. All we know is that they were paying for the free seminar. They invited everybody. They paid for the food. They paid for the speaker. They paid so the CLE credit, the CE credits would be issued. There's no evidence that they were there reaching out to anybody. Now, when they were reaching out to them with an offer of free stuff, it was about something relevant to what they sell. They probably deducted it as a marketing advertising expense. There is no other give people free stuff expense for corporations, unless it was charity. This isn't charity. The purpose idea, advertising is an action. So actions have purpose. So the fact that they talk about a purpose in another part of the statute, when they say any material advertising, the question is advertising doing, what is it? Advertising is doing something. It's an action. So there's a purpose behind an action. Well, and there was you brought up an example of Coca-Cola faxing advertising to Juul, but this court has an opinion where it ruled on Juul publishing an ad of Michael Jordan, and they said that was just because they were congratulating Michael Jordan, and this court said, no, that's advertising.
Okay, very well. We
Thank you.
appreciate the advocacy of both sides. We'll take the case under advisement. Our fifth and sixth cases are remote arguments. The fifth case is United States versus Michael Baird, appeal number 22-1877. Mr. Schultz, Mr. Bloodworth, can you hear us okay from the courtroom?
Yes, Your Honor. Your Honor, I'm able to hear you fine.
Okay, Mr. Schultz, over to you.
May it please the court, counsel for the government, Todd Schultz, Assistant Federal Public Defender representing the appellant in this case. Because no rational trier of fact could reasonably infer that the appellate intended to entice a minor, the district court's judgment and conviction in this case must be vacated. Appellant raised two issues in his brief. I'm only proceeding this morning on the first of those issues, that is a sufficiency of the evidence challenge. The second issue was decided by this court in the York case, subsequent to the briefing of the parties. The standard of review before the court is de novo. I acknowledge that a sufficiency of the evidence challenge is a significant hurdle, one that is nearly insurmountable, as this court has said, but nonetheless, I believe we're able to carry that burden this morning. The issue before this court is whether appellant's online messages can reasonably be inferred as an attempt to persuade, induce, entice, or coerce a minor. These words are not defined by the statute. They are, however, words of common usage and are ascribed their ordinary meaning. They're effectively synonymous. The idea conveyed by the words is one person leading or moving another person by persuasion or influence as to some action or state of mind. The ordinary meaning of these words entails something more than mere agreement. The ordinary meaning of these terms doesn't change depending on the context or the parties involved. Persuade doesn't mean one thing in the context of 2422B and something entirely different in the context of a consumer responding to an unsolicited advertisement. Based on appellant's conduct in this case, he could have been charged under federal and state offenses that prohibit sex with minors or travel with intent to engage in sex with minors. The enticement statute, however, is not one of those statutes. 2422B criminalizes the online attempt to knowingly persuade, induce, entice, or coerce a minor. The follow-up intent to engage in sex after the persuasion is clearly a separate and different intent. Congress made a clear choice in 2422B to criminalize persuasion and the attempt to persuade, not the attempt to have sex with a minor or travel with intent to have sex with a minor. The agents who orchestrated this sting gave no thought to 2422B's need for persuasion. The fictitious parent gave no indication that persuasion was needed and provided no opportunity for it. The agent's response to the appellant's first email asking that he supply more information about his advertisement on Craigslist for incest, the agent responds, quote, "no limit family fun," end quote. Occasionally at a jury trial, a prosecutor will ask the jurors to apply their common sense and life experience in deciding the case. I implore this court to do the same. And if the court does that, then I believe, based on life experience, based on common sense, everyone knows that you only resort to persuasion when it's necessary. No one attempts to persuade someone to do something they're already planning to do. That would be absurd. Common sense tells us that a consumer does not attempt to persuade an advertiser to provide him with the goods he's freely offering. It actually works the other way around. It's the advertiser who's attempting to persuade the consumer to partake of his goods. And that's precisely what the government did in this case. In this case, it literally posted an advertisement online soliciting individuals interested in incest and asked those individuals who responded to the advertisement if they would like to have sex with a fictitious 10-year-old child. In the district court, I analogized this factual situation to a case where a female undercover police officer posing as an underage prostitute approaches a John to ask him whether he's interested in paying for sex. No one would claim that if he accepted her offer for sex, that he had persuaded her to have sex. No one would claim that in asking her what services she was willing to perform, that he was attempting to induce her to have sex. No one would claim that if he asked her how much it would cost, that he was attempting to entice her into having sex. If the undercover officer said that she would require him to wear a condom, no one would claim that his willingness to wear a condom was an attempt to coerce her into having sex. The facts of this case cannot reasonably be inferred as an attempt to coerce the minor to have sex. He never attempted to contact the minor directly, never asked to speak with her. In fact, I would suggest there's no facts in the record which suggest the minor was even aware of my client's existence. Unlike other attempted enticement cases before this court, my client also did not attempt to use the parent as an intermediary to persuade his daughter. He never asked to speak directly with her. He does ask for information about her, but never asked to convey any information from him to her. The sad reality of this case is the minor in this case is treated by the government and by my client as nothing more than chattel. Her thoughts and feelings about the government's planned sexual encounter are never discussed. And that, quite frankly, is what distinguishes this case from other enticement cases before this court, such as McMillan and Hostler. Finally, I would note that with respect to the gummy bears, according to the district court, the gummy bears are one of the most significant pieces of evidence. The district court's comments in that regard are particularly troubling, as they suggest that the court, like the FBI and the government, conflated the offense of travel with intent to engage in illicit sexual activity with the offense of attempted enticement. I would also note with respect to the gummy bears that in-person persuasion is not criminalized under 2422B. That 2422B, of course, criminalizes only those forms of persuasion which use a means of interstate commerce.
Let me ask you about that particularly, because you're right, in McMillan and Hostler, we found a certain set of facts to meet 2422, and that's that third, what I'll call the third bucket of enticement. Direct attempt to use a parent as an intermediary to convey a defendant's message to the child. That's that third bucket. We said we find it here in McMillan, we find it in Hostler. But we are also bound, it seems, by our identification of two other buckets that other courts have found to meet the statute. We haven't found them yet, but we said, okay, they are out there. And that second bucket is finding the persuasion element satisfied when the defendant trades on the influence of a parent over a minor child, or because the defendant exploits the parent's ability to bring the child to a meeting place where the defendant could attempt to directly persuade the child, that in-person persuasion. So just exploiting the ability to get the parent to the meeting place so there can be this rendezvous. Can you tell me your response to this second McMillan bucket that we haven't found yet, but we've said other courts have found this bucket to satisfy 2422B?
Yes, Your Honor. Well, it's my belief that those other courts got it wrong, that this court is correct by only using that third bucket. I would suggest to you that using that alternative approach that other courts have applied robs the statute of its meaning. It essentially reads the words coerce, persuade, entice out of the statute. It would read the statute so broadly that it would be no different than 18 U.S.C. 2425, which criminalizes the transmission of a minor's name, address, telephone number, social security, with the intent to entice, encourage, offer, or solicit any person to engage in sexual activity. I would also note that simply agreeing with a parent to have sex at the parent's request with their child cannot, to the extent the English language retains its meaning, be viewed as an attempt to persuade. There's no attempt to persuade in this case, and I have very little time left, but I would reserve the last few moments for rebuttal if possible.
Okay, very well. Mr. Schultz, we'll give you a minute or two for rebuttal. Okay, for the government, Mr. Bloodworth, good morning.
Good morning or good afternoon, Your Honors. May it please the court and opposing counsel, Casey Bloodworth on behalf of the United States. Your Honors, I'll jump right into that discussion that we left off with Mr. Schultz, and I interpret Mr. Schultz's argument as an attempt to limit what was recognized in McMillan, that using an adult intermediary to communicate with a child requires either direct communication or a specific request to pass information on to the child. Now, first, I'll point out that under this standard of review, that there's certainly sufficient evidence where a reasonable fact finder could show that even under that limited interpretation of McMillan, that the evidence was sufficient. And I'll point out, as was argued in the government's brief, that during the conversation, the appellant sought clarification with the purported father on what he would be able to do sexually with this child. When he stated to the purported father, "Tell me what they want," as pointed out, a reasonable inference of him saying that was to invite dialogue with the purported minor on what sexual acts or particular sexual acts that child would be uncomfortable with. The appellant interprets that evidence differently, but as this court has repeatedly held, the evidence need not exclude every reasonable hypothesis of innocence, in which version of the evidence to believe is up to the fact finder. So even though the record, even under that limited interpretation of McMillan, the evidence is sufficient, the government doesn't read McMillan as to be so limited. McMillan was decided because the facts supported that narrow interpretation, but as Your Honors pointed out, there are other circuits and other schools of thought on the use of an adult intermediary regarding communications with those intermediaries and children. The attempts could be to persuade an adult to allow access to the child, exploiting a child.
But we did not adopt those other schools of thought in McMillan. We said we didn't have to.
Agreed, Your Honor. Agreed.
Are you urging us to adopt, that bucket number 2? Or are you resting your argument solely on this phrase, "Tell me what they want," meets bucket number 3, end of story?
No, Your Honor. I'm not certainly advocated that that's the only interpretation of the evidence. I think the court could decide this under that narrow interpretation of Millen with that argument when the appellant said, "Tell me what they want," as inviting a dialogue. A reasonable inference is inviting a dialogue with that purported father to determine the sexual limitations of their upcoming rendezvous.
How is "tell me what they want" inviting a dialogue as opposed to asking the father, you know your child, tell me what I'm going to get to do when I go in there?
Well, I think Your Honor's rephrasing of that illustrates the difference. Tell me what they want. Unless the father knew ahead of time what they wanted, in particular with this planned meeting, he would have to ask.
But the father is the one who told him he engages in incest with his daughter.
Very true. Engages in incest with his daughter, but at the outset of this conversation, the father said he was looking for something different. He was looking to watch another individual engage in sexual intercourse with his child. Your Honor, I'm not saying that that's the only interpretation of the evidence. I believe it's a reasonable inference, which is what we're under the standard of which we review sufficiency of the evidence, settles the question. I don't think that that's the only way to settle the question. We'll look at, to go to there's other question regarding gummy bears. If the court does adopt the second bucket, so to speak, of McMillan in using persuasion on an adult intermediary to allow access to children or provide a child for upcoming planned meeting, the gummy bears is direct evidence of that. But even more so, the gummy bears are direct evidence of an attempt to persuade using those facilities of interstate commerce. The conversation was brought up of this child preferring a certain type of candy, and it was indicated that candy would be a great start for a potential upcoming rendezvous. The appellant himself sought clarification of, well, is it any type or is it a specific type? What does the child prefer? And he was told not hard ones. Just a few short hours after that conversation and a few short minutes before he showed up at the purported minor's residence, he indicated he was stopping to get those. That's a clear attempt at persuasion. It falls under this court's precedent in what this court has decided, both in Hostler and McMillan, but would also fall in that second bucket of McMillan on using an adult intermediary to provide a future face-to-face encounter with a child. Just like the district court below, this record supports ample evidence and sufficient evidence where a reasonable fact finder could find that Mr. Baird committed the offense of attempted enticement of a minor. The appellant simply asking this court to do what this court has routinely refused to do, and that's reevaluate the evidence. The standard is that reversal is appropriate when there's no evidence in the record to support conviction beyond a reasonable doubt. There's certainly some evidence, and in this case, there's compelling, overwhelming, and insurmountable evidence supporting the district court's decision below, particularly with the appellant seeking clarification on what type of gift he could bring. This court repeatedly recognized in McMillan and both in Hostler that in and of itself is sufficient to show an attempt to persuade, induce, or invite. But as this court often cautioned, those are not the only an exhaustive list of types of evidence to support that element. In this case, there's abundant other evidence, such as what the district court found compelling, similar to Hostler, that Mr. Baird's communications could be inferred as an attempt to illustrate himself as an appropriate sexual partner. This back and forth about what the child would want to do, could do, and what the child would not do was similar and sufficient to show, just as in Hostler, that this particular individual would be a suitable sex partner for this child. That's a reasonable inference also, and when you view this evidence in light most favorable to the government, it supports conviction. And under the standard that's enunciated by this court over and over again, those reasonable inferences viewed in light of the government and in light of the verdict and in support of the verdict is only overcome with no evidence in the record to support that finding. If there are no other questions from the court, the government will rest on its brief and its argument and yield the time back to the court and to no appeals.
Okay, very well. Thank you, Mr. Bloodsworth. Mr. Schultz, we'll go back to you and give you those couple of minutes that were just handed over.
Your Honor, I appreciate the extra time. In closing, I would just note that there is no disputing that the appellant's conduct in this case violates numerous different federal and state criminal statutes. 18 U.S.C. 2422B is not one of them. The government made a decision not to charge him, although it easily could have, because he traveled from Kentucky, made a discretionary decision not to charge him with intent to travel with intent to engage in illicit sexual conduct with a minor. There are simply no facts in this case that display anything. There's no reasonable inference to be drawn other than appellant was willing to join in the FBI's pre-existing plan to meet with a fictitious minor for sex. Common sense, I do believe, resolved this case. This isn't a close call. Everyone knows that if an advertiser says, if you're interested in my good, please come to my store and buy it, no one would suggest that a consumer who shows an interest in a product, and sadly that's little more than what the FBI held this child out to be, that person is then persuading the person who is providing the good. And so I do think it comes down to the common ordinary meaning of the words in the statute, and those certainly require more than mere agreement. And it's also important, I think, as you look at the context of those conversations, to understand that from the beginning, there's no need to persuade. This father, the first response is saying he's into no limit family fun. So to construe anything that my client says as an attempt to persuade goes against common sense. Nobody takes the effort to persuade or entice or induce when it's not necessary. And the government made it clear it wasn't necessary.
Let me just ask you, Mr. Schultz, you are not asking us to walk back because we can't, our holding in McMillan that attempts to get a message, to convey a message to a child, satisfy the definition here of using an adult intermediary, are you?
No. In fact, what I am arguing in this case is there is no attempt to convey a message through the intermediary to a child.
Okay.
Thank you, Your Honors.
Thanks to both counsel. We'll take the case under advisement. Move to our sixth and final argument of the morning, United States versus Jason Rodriguez, appeal number 22-1575. I'm sorry, we have counsel in the courtroom. Thought we were remote. That's my mistake. Whenever you're ready.
May it please the court, counsel. I represent Jason Tyler Dominic Rodriguez. We've raised two issues relative to two counts of conviction. One is related to attempted enticement, and one is related to attempted aggravated sexual abuse with travel of a child less than 12 years old. Relative to both arguments, they deal with sufficiency of the evidence, in that there was no sufficient evidence as a matter of law by which a reasonable juror could find Mr. Rodriguez guilty. Relative to the attempted enticement, this is a third-party intermediary sting. The court's just heard argument regarding, I believe, a very similar, if not the exact same sting, with the exact same officers and the exact same district. It was a Craigslist ad that was posted that Mr. Rodriguez responded to. He testified at trial that he was running his own sting. The jury rejected that, his testimony. However, the text messages and the conversations and his actions in this case relative to a third-party intermediary do not support a conviction. This court's holding in McMillan said, under the facts and circumstances of that particular case, that third-party intermediaries could support a charge of attempted enticement. The facts that are existent in McMillan do not exist here. What the court has referred to as the third bucket of McMillan, having to do with the defendant talking to or wanting to seek or wanting consent or wanting interaction with the fictitious minor. That doesn't exist here in this case. The conversations between Mr. Rodriguez and Agent Wainscott had to deal with mostly whether or not Agent Wainscott was real or not, whether the fictitious child was real or not, the course and conversations about sending pictures, sending things to justify whether or not this was a real thing or a fake thing. There's no indication under the facts of this case that would be similar to that of McMillan to fall into that third bucket where Mr. Rodriguez is seeking to get consent from the minor. It just doesn't exist in this case. The Hassler case has to deal with the defendant in that case was seeking the agent, who was a mother in that case, to say and show a dress to the purported minor. Did the daughter like the dress? All of those kind of things. Those facts don't exist here. Mr. Rodriguez did not engage in the conversation that would support a third bucket with McMillan. The argument we raised, though, to go back prior to McMillan has to do with just the plain language of this statute. The statute says, whoever using an implement of interstate commerce attempts to persuade, induce, entice, coerce any individual not yet 18. That's just the language of the statute, not yet 18. It's been this court and other courts' constructs to say you can induce, persuade, entice by exercising conversation with a parent who may have influence or all of these other things. But that's not the plain language of the statute. It's persuade, induce, entice someone who has not yet reached the age of 18, which didn't exist here. There are numerous cases before this court There's more coming through where the defendants in those cases in these stings have had conversations with people that the FBI says are 15 years old or 16 years old. That would fall under an attempted enticement statute based on the plain language. But that's not the facts that we have here. There was no conversation with...
So you were asking us to overrule McMillan?
Yes. And that if you don't choose to do that under the facts of this case, you can find that it doesn't fall into the third bucket. McMillan and this third-party intermediary in this third bucket that the court has already adopted do not comport with the facts of this case. And McMillan is wrongly decided under this idea that there's some additional persuasion or experience that's outside of the plain language reading in the statute. As this court has just heard, there are numerous statutes, including Mr. Rodriguez was charged under those, by which this conduct fits, that the government could charge under. There's not only one statute that this conduct falls under. The government elected to charge under this statute, and under the plain language reading of this statute, Mr. Rodriguez's conduct does not fit all of the elements. Just under the plain language reading of it. There doesn't have to be an extension or a theory or a what if in order to find somebody guilty. It just has to be if you attempted to persuade, induce, entice, coerce any individual not yet 18. That's just all there is. The idea that people who go online to solicit sex with minors are unpopular or unlikable or should be punished, fine. But the government can do that in a number of ways. It has to, through its charging decisions, be consistent with what the plain language of the statute leaves, what it says, not yet 18. The government doesn't have to stretch to go any farther than to find a statute of which there are many to fit this conduct. Mr. Rodriguez's conduct under this particular statute does not fit, even with that third bucket of McMillan. In the first and second buckets of McMillan, or under it, I would assert to the court that's even getting farther afield, and that's even broader, and the court should not adopt those. That's getting farther and farther away from the plain language of the statute. By adopting only the third bucket in McMillan, I would assert that this court was wrong to do that, but at least it was more closely adhering to the plain language of the statute.
So why doesn't it adequately fit the statute on the fact pattern like here, where you have an offer of, you have a clear expression of interest in having sexual contact with a minor. You have an offer of money. You have a discussion about a gift that the child would like. And then the individual gets in the car, drives to the location, and has the gift with him. When you add all of that up, why can't you, in the totality, mindful of the content of the text exchange or the emails, conclude that the defendant took a substantial step?
Because the defendant did not take a substantial step toward enticing, persuading any person under the age of 18.
Yeah, okay, so let's do this. Let's within the confines of McMillan, so assume McMillan is circuit law, which it is, as you know. So within the confines of McMillan, how does it not fit?
Because he didn't ask for the agent to talk to the minor, bring back information, to have conversation with the minor, or like Hostler to show the minor, put on the dress, or would the minor like the dress, and then get back to me about whether or not the minor would like the dress. There's no interaction between
He says, I'd like to talk to her on the phone if that's cool.
And
what
that
do we
was
do with
to,
that?
That was to verify that the minor was real. In the course of that conversation, he's going through with Agent Wayne Scott to figure out whether or not this is real or not real. And the conversation about talking to her on the phone and wanting pictures is to verify identity and legitimacy.
Isn't that a substantial step toward the commission of the offense?
No, because he's not going to talk to the minor to encourage, entice, persuade the minor to have sex with them. He wants to talk to the purported minor in order to say that this is a real person, not a fake figment of law enforcement. And that was in the whole context of the series of those chats. that's what it was worth. I had reserved 3 minutes for rebuttal.
Yeah, you want to save the rest?
Thank you.
Yeah, very well.
Good afternoon, Your Honors. May
Good
it please
afternoon.
the court, counsel. My name is Tom Leggins, and I'm representing the United States here today, and I was trial counsel below also on this case. My prepared comments for this afternoon are very brief and not at all nuanced. I think the evidence in this case, most of which is contained in Government's Exhibit 43, details a series of conversations between an undercover agent pretending to be the father of an 8-year-old girl who was willing to allow strangers to have sex with her. He gets into a conversation with the defendant, and in the course of that conversation, with regards to his intent on both of the counts at issue on this appeal, the evidence was that the agent told the defendant, if you intend to have sex with my daughter, you need to show up with $150 and a bag of gummy bears to help persuade her. And it is our position that when the defendant showed up with those items, when the defendant shows up with the items he needed if he intended to conduct the sexual transaction with the minor, then that's all the jury needed to have to find intent in this case on both counts that are under attack in the defendant's appeal. Not only do you have the defendant then showing up, driving for 2 hours from St. Louis, Missouri to Marion, Illinois to the pre-arranged meeting place where there had been discussions about the fact that sex with the minor would follow the meeting. The defendant shows up with $152.
Does the crossing of the state lines alone satisfy the interstate commerce?
Yes, I believe so. In a I mean, these are all Mann Act derivative. Well, the travel with intent to have sex are all Mann Act derivative type statutes, and crossing the state line with the intent to have sex does satisfy.
So you don't need any aspect of the interstate commerce dimension of text message, or
you do on the enticement count. Now, I thought you were asking.
Yeah, I'm asking 2422B.
Yeah, on the enticement count, you do need an instrumentality of interstate commerce, and the text. Our theory at trial was that
on 2422B alone, not the travel statute. 2422B, would the traveling across the state lines with that intent against the backdrop of the prior exchange satisfy the interstate commerce dimension?
I think it would. I mean, I really hadn't prepared that question. There are the Lopez Supreme Court decision identified what various phrases within a statute mean in terms of what you have to show with regard to the interstate commerce element in that statute. And as I stand here off the top of my head, I can't remember whether it's in or affecting interstate commerce or whether it's in interstate commerce. I do know that our jurisdictional hook on this case and on the enticement count was it also included a computer, by computer. But generally, traveling in interstate commerce where there's an interstate commerce element will satisfy pretty much any interstate commerce element under Lopez, I believe. The Supreme Court case that interpreted the interstate commerce clause several years back.
Yeah, I mean, it's a little bit different. I mean, that's for purposes of the scope of Congress's Article 1 authority under the Commerce Clause. Here you're talking about the sufficiency of evidence in a criminal case.
Yeah. I think it would. I don't think in this case, I mean, we have to obviously we don't have to hang our hat on that. I mean, the interstate commerce, the sufficiency of the interstate commerce element wasn't even seriously disputed at trial. I think the main argument at trial...
Was it disputed at all?
No, not at all. The whole argument at trial, I mean, my closing argument was there's really no issue here other than do you believe the defendant was up to good, or do you believe he was up to no good? The argument at trial was over his intent, just as the argument here today is over his intent.
Well, no, you had to have the jurisdictional hook for the jury for your interstate commerce on this enticement count.
Correct.
So what did you explain to the jury? Because you weren't talking about travel across state lines for interstate commerce.
For the enticement count, we said the use of a computer.
But what did you point to him on the computer
Well,
doing
his cell
that was
phone.
persuading?
His cell phone. Under the jurisdiction, or under the decisions of this court, a smartphone, a cell phone, constitutes a computer.
Did you have an
and an
evidentiary
instrument.
stipulation, or what was the evidence? Did you have somebody testify from a phone company, or was there an evidentiary stipulation, or what was it?
Yes, there was an instruction that a cell phone connected to the internet is an instrumentality of interstate commerce. And there was really no dispute that he was using a cell phone connected to the internet in the course of pretty much most of the discussions contained in Government's Exhibit 43. So that was a jurisdictional hook on the enticement count and there really was, as I said, there really was no dispute. The on the issue of his intent, as I said, that was a whole issue that was litigated in front of the jury below, and it was he told the case agent told the defendant, if you intend to have sex with my 8-year-old daughter, you need to show up with $150 and a bag of gummy bears, and he showed up with both. And not only that, but he also showed up with a cell phone that was full of child pornography images and videos, which undermined his defense that he was out on some hero mission. It evinced his sexual interest in children, and the jury quickly rejected the defendant's arguments on intent. I also believe there are other, during my closing argument, and I really hit the fact that his intent could be inferred from the fact that he showed up with $152 when the negotiated price for the sex act was $150. He showed up with the gummy bears because he was told that's what he would need to persuade, induce, entice the 8-year-old girl into having sex with him. But we had all of the other Hosler and McMillan factors at play in this case, and I would differ with counsel. One thing she said, there was a discussion near the end, I believe it's contained in Government's Exhibit 43, where the defendant tells the ostensible father, the case agent in this case, tell her about me and get back to me and let me know what she says. So you have not only the direct evidence from the gummy bears, from the $150, but all of the McMillan and Hosler factors that play in this case, and it's the government's position that there is an abundant amount of evidence that is sufficient to sustain his intent to commit these offenses. And if the court has no further questions, I'll yield the rest of my time.
Okay, very well.
Thank you, Your Honor.
Thank you.
If crossing state lines in this instance would be sufficient to sustain a conviction for enticement, then there's a double jeopardy problem. They have to be separate if it's exactly the same facts, because he was also convicted of crossing state lines with the intent to have sex with someone under 12. So attempted enticement is a different statute from that. It uses a facility of interstate commerce, not just affecting interstate commerce. There's also discussion in law out there about how it's the asking, it's the enticement. Please meet me at Walmart, I will sell you my truck for $100, to get the person to show up at the Walmart. That there has to be two distinct crimes in this case for the same conduct, otherwise there's a double jeopardy problem for the conviction of both. If this court feels that exactly the same elements meet each statute, then one of the convictions would need to be vacated for double jeopardy, because it's exactly the same conduct. They have to include elements that the other does not. We had a lot of litigation below about the double jeopardy issue. And so I think that underlines my point that this attempted enticement statute is different. It has to be different than this crossing state lines in order to have sex. And that has to do with the asking of the minor. the purported minor. The enticement, persuasion, that the ask has to come directly to the any person under the age of 18, and that's what makes it a different crime. The conversation that the government refers to about tell me what she says is after the ask and after the agreement has already been made. That is at the very end, after they've already agreed on a meeting place, they've agreed on a price, that they've agreed on all of those kind of things. So that was not related to any inducement to persuade or entice the purported minor. The attempted enticement statute, as has been litigated in this district, you can go back to 2008 in a case called Gladish, Gladish, where this court said you can't just arrest people essentially for them making conversation and never showing up. There has to be more. And so it's the course of that encouraged law enforcement to go out and now only arrest the people that show up at the meet location. There haven't been a lot of cases where they're just arresting the people at home, and that was because of the language that this court used in Gladish. So true with McMillan. In the McMillan case, and recently decided the York case, when this court has said we're going to pour things into this third bucket, right? That if you have conversation with the agent that is through the third-party intermediary and it meets these specific things, that's how law enforcement has tailored their investigations. The agents almost go through a checklist of I'm going to say this and get them to say this, and then we're going to meet the definition as established essentially by this court in McMillan. That should not be the way. It should be the language of the statute, that these cases where the purported minor is 15 or 16 years old do meet the definition of attempted enticement of a minor because they're communicating directly with the person under the age of 18. These factual situations where you're using a third-party intermediary simply do not meet the plain language of the statute.
Okay. Thanks to both counsel very much. We appreciate it. We'll take the case under advisement. That concludes this morning's arguments, and the court will be in recess.